Good morning. Well, I'd like to think that we got about 15, 16 of you in the room, and we got people out there in the virtual world, and welcome to the Special District Association of Oregon. What do we call this now? We call this comprehensive overview of board members and staffs presentation. My name is George Dunkel, and I've been with SDAO as a part-time employee for years. I'm joined by our lead instructor, Eileen Akins, and Eileen will introduce herself here in a few moments, but I want to go over some logistical things with you. And hey, sir, come and sit where there's a handout, would you please? Yeah, there's one here, one there.
There's one over here.
Yeah, we got one over there. Tim doesn't bite, so we're good. Not that you do. We're not sure.
Are you sure about that? I'm on the board with.
Yeah, maybe you should sit separate. I get it. I get it. We're here at Temecula Community College, their Eola facility. And we just got it set up this morning. We may have a few technical difficulties, but we'll work through those as we go. I normally go over some logistical things because I'm used to everybody just being here, and there's things you probably want to know that doesn't apply to the virtual people, but just so that we go over it. The restrooms are straight out the door there. You probably saw them. If there's any kind of an emergency, we just have the one door, but you can go left or right once you go in the hallway. At any time today that you have a question, we ask that virtually we're going to have them raise their hand, right, Kaylee? They're going to raise their hand. Kaylee's going to monitor back there in the room. Raise your hand. Either I or Eileen will interact with you. There is sometimes you're going to ask a question that we know we're going to answer a few slides later or this afternoon. So please don't be offended if we say, hey, we're going to get to that. You just may be ahead of us. We are going to provide you with a break this morning, about a 10 to 15 minute break. We'll have lunch. I believe lunch is being brought in, Kaylee, for those of you that are here. Virtually, good luck. I don't have any lunches for you. You in the room and then you at home or at the office. We understand all of us have cell phones. All of us have work just going on with you here. You may get a call. Please have your phone on silent. If you do need to get up, one of you have already mentioned to me that you may have to leave early. If you need to take call, we will not be offended. We get it. Just get up, excuse yourself, go outside and do what you need to do. Those in the room provided with some handout material. How are they getting it virtually? Is it online? The handout materials? Multiple emails. They got emailed. Okay. They can email Kaylee and get it sent to them. Okay, good. For those of you in the room, if you do have to leave early or when we're done this afternoon, we'd ask that you please leave your name tags. We recycle those, try to reuse them. In your handout material is a evaluation form. We really appreciate you filling that out. Let's see if it's pink. It is pink. All right. There are different colors for different places, so I never know. Yeah, please fill this out. Just either leave it on your place or hand it to Kaylee as you leave. Again, my name is George. I'll be here with you all day. I was part of the instructors, but we're going to turn you over now to our lead instructor, and we are finishing.
Hello.
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 Can you hear us?
Sorry.
Okay.
Can you communicate with them and let them know that we can hear them? We can hear you.
We can hear you. Yeah. That was good. Okay, that messed up my thinking. I thought God was calling me there for a minute. Anyway, I'm going to turn it to Eileen now, and she'll introduce herself and get us started this morning. Thank you.
Will do. Thanks, George. Morning, everybody. Morning, everybody in the room and everybody in virtual land. Welcome. As George mentioned, my name is Eileen Akins. This is me up here. I have a tiny little law firm, Northwest Local Government Legal Advisors, which rolls off the tongue. That's me. My contact info is there. Let's see. A little biography about me. I went to work for the Special Districts Association shortly out of law school. I had a career in public relations communications prior to law school. When I went to law school, it was the mid-90s. Then I got out and we were in a recession and nobody was hiring lawyers, but I ended up getting a job with the Special Districts Association doing communications and public relations. I planned their annual conference and was their education and publications director, did their newsletter. planned classes like this. So back in, kind of come full circle. So that was back in the 90s. I worked there for about 4 years. Planned again all their events and did their communications. And while I was there, I met the guy at that time who was their attorney and also represented a bunch of special districts, and that was Andy Jordan. The law firm, some of you have been around for a while, remember that name. That law firm at that time was Tarlow, Jordan and Schrader. It's changed names a few times, but it's still out there. I worked with Andy for about 6.5 years. He and I were the local government department, if you will. Andy was my mentor and an excellent one for many years. And then I got to junior partner there, and then I decided to hang out my own shingle in 2006, primarily because I was a single mom and I needed more flexibility than I could get with a larger firm. So took a big leap of faith and decided that this is the work that I wanted to do. And I hung out my shingle then, and now I have, since then, my clientele is almost exclusively local governments, primarily special districts. I have about 100 or so special district clients of different kinds, a couple cities, occasional county, but that's the work that I do. And I when I started with the Special Districts Association, I had no idea what a special district even was. And I think that's common for people who don't work in this field. And so I sort of fell into this by accident, but I found that once I started to do it, I liked it very much. And the main reason I liked it, I found, was that I liked working with people like you. And by that, I mean people who are, for the most part, dedicated to your work, you're mission driven, you're not profit driven most of the time. You believe that you are part of your community, which to me is a value of mine. I think community is a somewhat underrated and somewhat undervalued thing in the world in general, and certainly now. So I enjoy being a part of the team and helping you guys do the work that you do. So I'm grateful that you're here, virtually or otherwise. Thank you for getting this training. It is important work. And I'll be your cheerleader for doing it right and doing it well. One little caveat, I am an attorney in private practice. I have a law firm. I have clients. I am not an SDAO employee. They contract with me to do this work. If you want free legal advice, get it while you're in this room, while it's on SDAO's dime. If we leave here and you have questions about anything we've talked about, direct them to someone at SDAO, or if you want to become a client of my firm, you're welcome to do that. But once we're out of here, then you have to be a client for me to advise you. Okay. So let's see, that's about all the background I think I can give you for now. As George mentioned, we welcome your questions as we go. As we're all used to by now, we're going to work with the technology to the extent we can to try to make sure that those who are attending virtually feel like they're part of the class as well. Questions are welcome as we go. If we need to, we are going to be covering a lot of ground here. We've probably anticipated many of your questions, but and so we may just say, hang on, we'll get to that. And then we'll, at the end of every topic, we'll have an opportunity for you to ask questions as well. So those of you who are attending virtually, you are part of the class. So feel free to ask questions as they come up. If needed, Kaylee will moderate for us. Can I get a sense of who, it's hard for the people, I'm not sure whether we can do polling with the group. Usually we can't, but for the people in the room, how many of you have taken this particular dog and pony show before, the one George and I do? Oh, about almost half. Okay, great. Thank you for coming back. Either it was really good or you didn't get anything out of it. One or the other. Usually it's the former, but you never know. Of those of you who are here, anybody who has been doing what you're doing for, let's say, a year or less? Couple of you, brand new. Good, excellent. You're in the right place. Anybody here who's been doing it for, say, well, I don't know, 20 years or more? Couple of you. Okay, good. And presumably everybody else in the middle. Everybody, of the people who are in the room, how many of you are on a board? Okay. And the rest of you staff, presumably? Anybody who's anything other than board or staff? Okay. Once in a while we get an outlier, a lawyer or an insurance agent or somebody else. Okay, great. That's helpful. For those of you who are brand new, thank you. There is a big learning curve, particularly if you've never done this kind of work before, but it is learnable. It just will take time. And as you can see from the experienced people, the longer you do it, the more you realize how much you don't know. and how much you would benefit from a little more education. There also is the fact that the laws do change over time. So those, people who are kind of conscientious learners will continue to come and kind of get refreshed on anything that might have changed. So those of you who are very experienced or even moderately experienced, we appreciate that you're here too. We can often learn from you in the work that you are doing. All right, I'm going to go ahead and get started. As George mentioned, we do have a lot of ground to cover today. I am not working with a microphone today. If in the back I start to peter out, please let me know because my voice will get tired after a while. George can fill a room anytime, any place for as long as he needs to. I may wear out, so let me know if you have any trouble hearing me. We will take a break once in the morning. We'll have a break in the morning. We have about a half an hour for lunch. As George mentioned, we'll take a break in the afternoon. So if you start feeling antsy, please see if you need to excuse yourself. Nobody's going to be offended, but just in case you start to wonder, are we ever going to get out of here? Well, you will. Okay, we planned that. And our hope, this is our final one in the series. We've had 6 around the state, and this is the final one. We may be a little punchy, but I know I am, which kind of will make it more fun, I think. But our experience has been that we finish somewhere between 4 and 4:30, usually, 4 if we're doing really well, and about 4:15 in most cases. So we will get you out of here on time. Okay, I'm going to go ahead and get started. And by the way, these are the slides that you have here. George and I are both going to be working from them. They are an outline of the things we're going to talk about. You have these in your materials. We know for next time we do this that we need fewer slides per page because in many cases the type is teeny weeny and you can't really read it all that well here either. But I'm going to be walking through it with you, and just so if you need to track that the slides are numbered, so you can follow along with your materials. But those are what you're seeing up here. Okay, same thing. All right, the topics we're going to talk about, and some of them are kind of lost here in the gray of the slide, but I'm not sure I can read that here. We're going to talk about powers and protections of special districts. That's always a good foundation. We'll talk about roles and responsibilities of both the district and the board. We'll have a short course on public financing, another section on public contracting. Our lunch break will happen right around in here. Then we'll come back and talk about public official ethics. We'll talk about public meetings and public records in the afternoon, and then we'll wrap up. I did a little bit of a survey of some laws that recently passed that may affect some of you in this room. And then we kind of wrap it up with a summary of what SDAO has available in terms of risk management and loss prevention. So that's the final slide. All right. So to get started today, we're going to talk about powers and protections of special districts. It's always the place you want to start. Special districts are, not every state has special districts. Oregon obviously does. Colorado does. California does. Some states have something like that, but they don't necessarily call them special districts. But just for orientation, a special district is a municipal corporation. Okay, that we have the state of Oregon, which is the state of Oregon, and then we have counties. That's divided up. Those are forms of local government. Within those counties, we have cities, which are municipal corporations, and they have their own sort of stuff that applies to them. And then and we might have a regional government here or there. And then the special districts are another form of municipal corporation, comparable to a city, but with different types of authority. You are municipal corporations. You operate as public entities and public corporations as compared to the private sector. So you are your own little individual legal unit. Okay, that's helpful to know because as we go through here, you'll get a sense of how the laws, in terms of what you do and the laws that apply to you, you are a municipal corporation and must behave accordingly. So with that said, we'll talk about the authority of the district, the duties of the board, and the authority of the board, and we'll finish up this section with a discussion about sovereign immunity and the protections that are available there. All right. When we talk about the authority of the district, because the district is a local form of local government, there is something called Dillon's rule, which local government people can recite for you, but it isn't a statute, as it is a case law. It's a theory of local government operations. And what it says is that a local government may exercise powers that are expressly provided for by law or are necessarily implied. If in comparison, if you work in the private sector, you work for a private corporation, Google or Nike or whatever company you might be coming from. In the private sector, the general rule is that they can do pretty much whatever they want to do as long as there's not a law against it. Okay, as long as they're not illegal, they can get as creative as they want to. They get new product lines and subsidiaries and mergers and, their goal usually is to make money. Okay, so as long as they're not breaking the law in our capitalist society, it's okay for them to do as creative and entrepreneurial as they want to. In comparison, because governments presumably are not profit driven, what you are allowed to do are the things that the law says you can do expressly. Expressly means written down somewhere. Okay, there is express authority for you to do what you're doing. And then there's necessarily implied, which is you couldn't do the written down stuff if you couldn't do the necessarily implied stuff. And we'll elaborate a little bit on those. So we always start from that position. So we talk about special districts authority. I'm still going to sort out where I can stand, and I have to be over here to be in front of the camera, but not in front of the screen. So this will be interesting. Okay, when we talk about authority of the district, each type of district has a special amount of statutorily provided authority. Special districts are considered creatures of statute, which means that there is a written down law that applies to just about everything that you do. Okay, and you are governed by statutes within the state of Oregon. So for almost all of our conversation today, we're talking about Oregon law. Occasionally we'll touch on some federal stuff, but for the most part, we're talking about Oregon law. And in Oregon, our written down laws are Oregon revised statutes. So it's a code of statutes and it's abbreviated ORS. So when you see that abbreviated, we're talking about a statute, Oregon revised statutes. For special districts, the first chapter we would always look at is chapter 198. These are all available online, by the way, if anybody is wonky enough to want to go look them up. If you went to ORS chapter 198, it governs special districts generally. And in that, you will find, how to form a district, how to dissolve a district, mergers, consolidations, all those boundary change things are in there. There's also things like how to adopt an ordinance if you're a special district, or the board compensation that some of you might be receiving. That's coming out of chapter 198. And that applies. And if you went there, it would list all the special types of special districts to which these laws apply. Probably more importantly, and well, not probably, certainly more importantly for our discussion today, we're concerned about the Principal Act. You will also see this, referred to as your enabling legislation. For every type of special district that you are, there are about 1,000 or so special districts overall in Oregon, but each of you, depending on the type of district you are, has a separate authority, and that is coming out of your Principal Act. So every type of special district that you are, there is a chapter in the code that talks about what authorities you have. So anytime, whatever type of district you are, you want to know what chapter to go read so you know what the scope of your authority is. Does anybody here want to share with us what chapter you are authorized by, if you know it? Yeah. 450. 450. Are you a sanitary district or an authority? Water authority. Okay. 450 covers sanitary districts and water and sanitary authorities. Okay. Anybody else know? Yep.
I think 479 for fire district.
478. For one off. I don't know what 479 is, but you go look at it. It might be related to what you do. There's usually statutes are grouped together. 478. Fire district. Anybody else? Yeah.
190 for a
IGA.
cooperative between 3 special districts.
Three, 4 minute forward.
Okay. All right. So you're an IGA entity, or are you just, it's just an agreement?
On both boards.
You're on both boards and you cooperate through an intergovernmental agreement,
Yeah.
through 190. Okay, interesting. All right. Anybody else? And what type of district, if you don't know, what type of districts do we have here? Small enough group we can do. Soil and water, 568. Anybody else?
Water authority.
Water authorities, you're in 450 as well.
Transportation.
Oh, golly. You're in the 400s somewhere, I believe. That's not one I can rattle off the top of my head, but we can find it. Okay. If you went to 198, chapter 198, it lists all the districts that it covers, including whatever your statutory authority is. So that's a helpful resource as well. Okay. Anybody here who doesn't know and wants to know? Okay. So you get the idea. So if at the break you're like, I don't know, and I didn't want to say I didn't know, we can look it up for you, but that's always the place you want to start. Okay, because you are given expressly provided authority through whatever that Principal Act is. And many of them are similar. They'll say things like, the board has the authority, or the district can sue and be sued in its own name. And it has the right to, you may have the ability to assess a tax. It'll say that in there, or to go out for bonds, and it'll say that in there. And it'll have usually a paragraph that talks about what the board's authority is. Like, does the board have the authority to enter contracts or to adopt rules and regulations, et cetera? It also have in their board qualifications, like what does it take to qualify to be on your board? How long are your terms? All of that stuff will be in your principal act, okay? So the place we always start is what type of district are you? And if you want to do something, then we always look at, see whether that is in your expressly provided authority, because if you're acting outside of your expressly provided authority, that's ultra virus, which is the legal term for outside of your authority, and it's illegal. For example, a water district cannot provide park and recreation services, and a park district cannot fight fires. And so you get the idea. So you are a special district because you have specially granted authority to do something. All right. All right. So, and then every other thing that you do, there is a statute that applies to it. There's elections, special district elections are here in 255, and then bonds, there's a statute, and contracting, which we're going to talk about later today, is in this set of sub chapters. So there's statutory authority, all right, written down laws in the Oregon Code, all right? And then also there are administrative rules, which you will see abbreviated as OAR, which stands for Oregon Administrative Rules. Oregon administrative rules are adopted by state agencies. Okay, the state has a bunch of agencies who are responsible for adopting rules that implement the laws that apply. Okay, in many cases, the administrative rules are there to govern state agencies. Okay, that's what they're there for. However, some agencies have authority over some of you in the work that you do. Water, is there do you have any sanitary people here, sanitary authorities? Yeah, I'll say, what is the regulatory body that has rules that apply to you? Do you know? DEQ. DEQ, excellent, yeah. DEQ has authority over sanitary stuff, all right, and as they should. Water districts, water authorities for community water systems, the Water Resources Department has rules and regulations that apply to water and what needs to be in the water and how often you test the water, et cetera. So you get the idea, all right? So the administrative rules will apply to you. It's less about authority that's given to you than it is about, you know, implementing the way that you carry out your duties. That'll be the Oregon administrative rules. And then we have ordinances, and George will talk later about how to adopt an ordinance, and it's very process heavy, but it's essentially a law that your district is authorized to adopt and implement against somebody else. All right. So whatever rules and regulations, like, your rules and regulations for connecting to the water system are adopted by ordinance. And the reason they're laws is because you can enforce them, meaning that if somebody doesn't follow them, you can assess a penalty. You can shut off their water. You can assess a fine. You can put on a late fee if they don't pay their bill on time, et cetera. So ordinances are local laws. Not every type of district has the authority to adopt ordinances. Soil and water conservation districts, for example, do not. Water districts do, sanitary districts do, fire districts do. In the Oregon Fire Code, you adopt that. That is an ordinance that you can then enforce against the people within your jurisdiction. Okay, so these are the written down laws. This is the source of your authority and the limitations on your authority. Then there's also necessarily implied authority, which is kind of what it sounds like. I mean, your principal act might not say that you can hire employees. It might not say specifically that you can enter contracts, but those are the kind of things that if you're going to be able to do the written down stuff, you're going to need people to do it. You're going to need contracts. You're going to need that stuff. So that's necessarily implied. Pretty narrowly defined, but and that's the scope of your authority. If it's not written down or necessarily implied, you don't have it. All right. Okay. So from there, any questions of the authority of the district before we move on to the next topic? Yes.
You mentioned ordinances. Can a water district place a lien on the property because their resident is delinquent in their payments?
Yes. Yes, and you would do that through your ordinances, and you would need some coaching on how to make it legal, but yeah, you can attach it. Any other questions? Okay. All right, let's talk about the duties of the board. Okay, because you are a municipal corporation, you are governed by a board of directors, just as you would if you had a private corporation. There's a governing board. You follow their bylaws, et cetera. For your district, you have a governing board. It's the board of directors, board of commissioners, whatever you call yourselves. Okay, they're the governing board of the district. And they have certain duties. They have fiduciary obligation to operate the district in a responsible way. All right, and that includes you ensure the district operates legally and fiscally responsible manner. Okay, Only the board can enter into contracts. Only the board can bind the district legally to any obligation. Okay, we're going to talk about ways to delegate some of that authority, but the buck stops with the board. Okay, the board is the decision-making body, and they can enter into legal agreements on behalf of the entity. They also oversee financial operations, including adopting the budget and ensuring the budget is properly, administered and money is not spent improperly. That buck stops with the board as well. They establish legislation by ordinance. If you have the ability to adopt an ordinance, the board is the one who would adopt that. Okay, and there's a process the board is required to follow to do that. The board adopts district-wide policies. So a policy that applies to how you govern your internal operations, like your contracting rules or your employee policies, or, your public records operations, which we're going to talk about. Those are all internal policies, but the board adopts those because they apply internally to your operations. Okay. The board can delegate authority when it's appropriate, primarily in the area of contracting. We're going to talk about how to do that. But the board has some authority to delegate authority to either other members of its body or staff. Okay. When we get to those areas, I'll explain how that works. And then the board's supervises, if you have a chief executive officer, like your fire chief or your executive director or your manager, the board, the way it's supposed to work ordinarily is the board of directors supervises that person. Okay. And they're responsible for supervising and hiring and firing and disciplining that person. And then that person is responsible for everybody, who is subordinate to that person. Okay. That's ordinarily how it works. Okay. So those are the duties of the board. All right. Here's an opportunity for you to get involved. Individual board members, I'm sorry, question? Oh, sorry, let me back up.
It's actually a follow-up from the previous question.
Okay.
And Rick asks, instead of a lien, can they just shut off the water?
Okay, well, we're not going to get into specific authorities of different districts. Thank you. Yes, you can, but talk to your lawyer about that. Okay, I don't want to brush you off, but as you can see, we've got a lot to cover today. And so I don't want to get in if you have a specific question about your specific district, and it's something you should be talking to a lawyer about, I'm happy to talk to you at the break. Okay. But yes, you can. Okay. The authority of the board. Individual board members have the power to engage in the following tasks without the consent of the rest of the board. Choose all that apply. A, attend board meetings by telephone. B, establish policies. C, review personnel records. D, direct staff. Or E, sign contracts. It's going to fall to the people in the room to do this because I don't think we can poll the audience in the virtual world.
None.
And none of the above? A. E. E. Did you say E?
There's someone online saying A.
Okay, A. We hear an A, we hear some, none of the aboves, and I heard an E. All right. Let me just end the suspense for you here. There we go. For those of you who said A, that is the correct answer. Okay, and I'm going to walk through each of these with you. Now, remember the question is individual board members. Okay, you as an individual board member, what authority do you have without engaging with the rest of the board? The board members are elected or appointed to fill an elected position. Your job is to attend the meetings, participate in the conversation, and vote. That is it. All right. Yeah, I mean, you have some authority as a politician to go out and represent the district, et cetera. But in terms of governing the district, the individual board members, that's your role. Attend the meetings, participate, and vote. All right. You have no authority outside of that unless the rest of the board says so. All right. So in this context, attending board meetings by telephone, yes, an individual board member has that authority, that ability to do that. You attend. Yes, you can do it by telephone. That's kind of thrown in as a little bit of a red herring. When we get to public meetings, we'll talk about that. But board members, for as long as I've been practicing in this area, have the ability to attend by telephone as long as the public can hear what you're saying and follow the conversation. So yeah, individual board members can do that. Establishing policies. Only the board collectively, like we talked about before, adopts internal policies. They usually do them by resolution. We hereby adopt these as our employee policies or whatever policy you're adopting. The board does that collectively. We'll talk about how to do that in a second. Reviewing personnel records and directing staff are both in the same realm, which colloquially we refer to as micromanagement, all right? Which is usually the staff in the room are like, because it is not uncommon in my experience, especially people get on boards sometimes because they have a beef, all right? And it might be a legitimate beef, it might not be. But they're going to get on the board, and a lot of times it's that manager is corrupt, and I'm going to get to the bottom of that, and I'm going to save the day, and I'm going to get in there, and I'm going to dig out the rot, and I'm going to save everybody. Well, okay, that might be necessary, and you might be right. However, what you don't have the right to do is just because you're on the board, it doesn't give you any special access to records. You are like an ordinary citizen. When we talk about public records, we'll talk about that a little bit more. But unless the board has authorized you to get in and dig through records, then you don't have that authority. And where I find it is the staff, I'll get a phone call from one of my clients, the manager saying, board member Jane is in here demanding records. Can she do that? And I'll say, well, no, the board didn't authorize her to do that. No. And then they'll be like, can you tell her that? Because she's kind of my boss and it's really awkward. And it is. It is awkward. It puts a staff in a horrible position. All right. Don't, if you can, don't do that to your staff. If you have it, and the same with directing staff, there's that sort of, well, I'm on the board and I'm your boss, so I'm going to come in here and tell you what to do. You don't have the authority to do that. And if you do that, it will not make you, the staff will not like you better because you're taking that initiative. There are ways to do that, to manage the staff component of this, but the way to do that is bring your concerns up to the board. The board will talk about it. And if the board agrees that, okay, there's something here that needs to be investigated, they may delegate that authority to you to go do that or somebody else. Okay. That's the appropriate way to handle that. It is not you vigilante board member getting in there and mucking with the staff. Okay. That is not your job. Okay. And similarly, signing contracts, as we talked about before, only the board has the ability to, the board collectively has ability to bind the district legally. A contract is a legal obligation, okay? So if the board is going to do that, the board has to do it collectively. They can assign some, as we get to public contracting, we'll talk about delegating authority to somebody else, but unless that authority is delegated, the board has to agree and adopt collectively any contracts that you enter into, okay? Question?
Can the board establish internal policy that restricts the authority of board members to attend board meetings by telephone?
So the question, if you didn't hear it, was can the board adopt a policy that restricts the ability of members to attend by telephone? And the answer is no. Okay, the ability to attend a board meeting is what is granted to you when you are elected. All right, and the board can't limit that authority in any way that undercuts the authority in the statute. There are times when whatever your principal act is may talk about that, in some, very rarely, but some districts in your statute, it will talk about the fact, I think George will talk about this later. It will talk about, if you miss a certain number of board meetings, you're off the board. Okay, if the statute says that, then that is how it works. But the board can't decide amongst itself at what point can we boot you off the board. Okay, George will be talking about that a little bit later. I don't want to steal his thunder, but so the answer is no. You can't do that. Okay. Any questions about the authority of the board before we move on from here? Okay. Whoops. Board action. Okay, when the board takes action at a meeting, it must be at a properly called public meeting. We're going to talk about public meetings after lunch in some detail, and we'll talk about how to properly call a public meeting. Okay, if the board is going to take action and have it be legally binding and legal, it has to be done at a properly called public meeting. Requires a quorum to be present. Okay, so what's a quorum? Majority. Okay. Anybody? Does anybody in this room have anything other than a 5-member board? What do you have? 7. Okay. What do you guys have? 7. It's almost always 5, sometimes 7, occasionally. We don't have any road districts here, do we? That's 3. That's a 3-member board. Okay. Anybody other than 5 or 7? Okay. So for a 5-member board, what's a quorum? 3. For a 7-member board, what's a quorum? 4. There you go. Okay. Quorum must be present. Well, again, we'll talk about that in the context of public meetings, but a quorum has to be present. And then most decisions, I say this is generally is doing a little bit of work here, but let's assume for almost all purposes that anything that you guys decide has to be decided by a majority of the board, and that is not a majority of the quorum. Okay, so let's say you have a 5-member board and 3 of you come to the meeting. Let's say those other 2 positions are vacant. You haven't filled them yet, okay? But you have 3 people, which is a quorum, right? Of a 5-member board, and they all attend a meeting and you take a vote on something and 2 vote yes and 1 votes no. Does it pass? No. Okay, and I'll get, about once a year, I'll get that question from somebody, from a client of mine. Because the way that that is supposed to work is that you have to, the intention is that the votes must represent a majority of the people of the positions on the board, whether they're filled or not. Okay, so if you have a 5-member board, you're gonna need 3 to approve anything. And whether or not, you know, a quorum has to be present, but you need a majority of the people of the positions on the board. That's why vacancies create problems, or not attending board meetings creates problems, because it can limit the board's ability to vote on things, okay? All votes have to be taken publicly. We're going to talk about executive sessions quite a bit, but any vote that's going to be binding for the district has to be taken in public. There's no anonymous voting. There's no secret ballots. There's no let's vote before the public comes back sort of a thing. You can't do that because all votes, you as a member of the board, you are accountable for your voting record. And as awkward as it might get sometimes, you don't get to do it secretly, okay? All right. Any questions about any of that we've covered so far? This is all foundational stuff. We're going to get into the real meat in a minute. Okay. All right. Legal protections. Yes.
Question is, can a present board member decline to vote?
Can a present board member decline to vote? They can abstain. I personally, one of my own little private soapboxes is over the years, I've listened to people talk about why they abstain. Abstaining when you have a conflict of interest is appropriate and necessary, and George will talk about that. Abstaining maybe because you've been in a coma for the last 6 months and you're just catching up, that might be valid, all right? Abstaining just because you're mad and you don't want to play this game anymore and you're going to pitch a fit and abstain, don't do that, okay? That is not what you're elected to do. But yes, you can always abstain. Board members always can abstain from a vote. But if you disagree with what's happening, rather than abstain, what should you do? No. Yeah. I mean, George will talk about that as well. But yeah, abstaining has its place. All right. And yes, you can do that. But I wouldn't get, you know, don't make it a habit of abstaining because that's not what the voters elected you to do. Okay. Yes.
Well, you talked about a conflict of interest. There's situations where, like, you have a quorum, but then there's a conflict of interest and people will step out and then suddenly you don't have a quorum. So how does that work?
I think George will talk about that when he gets to ethics. Yeah, he's going to talk about that. I could tell you in this context, but
Okay.
he's entitled to his moment. Yeah, I could tell you, but then I'd have to shoot you, and George knows about that. Yeah.
Meetings, what we do.
Exactly. There is, those of you who've done this before, George and I have been tag teaming this for quite a while, and he has the things that he is responsible for and the ones I'm responsible for, and we try not to step on each other's toes. So I won't do that. All right. Good question, though. All right. I want to talk about a concept. First of all, I want to say for those of you, especially for those of you who are new, I think if I had a goal for you to leave here, primary goal is I hope at least one thing of value comes out of this for you, at least one. But you should leave feeling a little bit terrified because there's a lot to know. And I want you to walk away also, though, feeling a little bit reassured and a little bit confident, okay? Because there are protections available. You are undertaking a big responsibility, but there are protections in the law to help you, okay? If you are willing to sort of, you know, do your best. And what I want to explain is a concept called sovereign immunity, which is not something you have to know, but it forms the basis for some of the protections that are available to you, all right, in law. The concept of sovereign immunity, we brought it with us from England. It was something that predated us back in, you know, the Magna Carta times. The concept is that the average person, the average plebe, you know, the average serf, can't sue the king unless the king says you can. All right. And the king gets to decide, how can you sue me? How dare you sue me? If you're going to sue me, it must be under these terms. Well, we don't have a king in this country. We have government operates differently. So the idea being that The sovereign in this case, for our purposes, is the state of Oregon. Okay, every state can decide the degree to which a government can be sued and how. All right, Oregon does that. And so if somebody's going to bring a lawsuit against you as a district because you are a municipal corporation and they want to sue you, then there's statutes that apply to that. And I put them in here if you want to go look them up. Sometimes when we get legal wonks, they like to look them up. And then there's nothing preventing you from looking it up. You don't have to have a law degree to look up a statute. Contracts. So if you, let's say your dispute is about a contract, you breach a contract, somebody else did, and you want to sue for breach of contract. For government entities, you're treated like any private person would be. All right. The contract law is what it is, and you sue and you prove your damages and all that. Okay. No special treatment for contracts, but you are allowed to sue and be sued under breach of contract theory. Similarly for quiet title, which doesn't come up often, but those are disputes about boundaries, property boundaries. Like, you have built your fence on our fire district land. No, this is my private farmland and you built your fire district on my, those kind of fights. Those are quiet title and you can be sued or sue, but you're again treated like any private party would be, and there's no special hoops that have to be jumped through there. The big one, however, which you probably have heard about, at least, tangentially, is tort. So anybody who feels confident with this, tell the class what a tort means, if you know. Anybody know? You're like, I might know, but I'd rather have you say it.
Like a wrongful act.
Very close, exactly. Wrongful act. And maybe the most helpful way to come at this is, well, there are crimes. There's the criminal law. Okay, the crimes are crimes. All the laws are there to protect us from each other. That's really what they're about. All right, we need these laws in a civilized society. But the law is there the criminal law is enforced by the state, which means the police, the police representing whatever the government unit is. All right, so crimes are harm that's inflicted, but there's a public safety interest in making sure the laws are followed and they're enforced by the state. Okay, that's the criminal law. In comparison, we have tort, which is civil law, which is our ability to sue each other. All right, and it's not a crime has not been committed. That's handled differently. What we're talking about is a civil claim. In order for a tort to be a tort, the legal definition is somebody has a duty to someone, like to do something or not do something. And that duty was breached. Like it was your duty to do your job and in the process not hurt me. Okay, that was your duty. And there was a breach of the duty and you have then committed a tort. All right, so if you breached your duty, you were supposed to do something or not do something, you breached your duty. And as a result of your breach, I incurred some harm. Okay, you hurt my body, you hurt my family, you killed me, you hurt my property. I have incurred damage because of your tort. Okay, you torted me. That's not really a term, but it's kind of fun to say that. Okay, so, all right. So the idea being civil wrongs. Okay, so your explanation is an apt one. All right. So citizens suing each other. Governments can be sued in tort. Okay, but the Oregon has something to say about that. And what it says is the Oregon Tort Claims Act. All right. So it defines, yes, you can sue a government entity for harm that it has caused or allegedly caused. But here's how that's going to work. All right. There's some procedural stuff, but the primary thing I want you to walk away with are two things. This is coming out of the statute. So subject to the limitations, we're going to talk about this. Every public body, so that's your municipal corporation, your district, is subject to action or suit for its torts and those of its officers, which in this case means the board, employees, which includes employees and volunteers acting as, like employees. And then agents, which is kind of a limited thing. We won't get overly concerned about that one. But if you are acting within the scope of your employment or duties, then the sole cause of action in tort, so the lawsuit, can only be brought against the public body only. The public body is required to indemnify the individuals, okay? If you are acting within your course and scope, so you're just doing your job, even if you do it badly, even if you screw up, if something bad happens and it's your fault, but it was all part of your job and you did your best, all right? Then the Oregon Tort Claims Act requires the public body itself as a corporation to indemnify you, meaning that it says, don't sue them, sue me, all right? I am taking the hits for my people, all right? That's how that works. So this is the protection for those, particularly those who are new to this area. They're kind of like, oh, do I need extra liability insurance? Am I going to lose my house? You know, what if I mess up? And the pressure, my gosh. We want you to do your best. All right. That's why you take these trainings and why SDAO wants you to take these trainings is because you want to learn how to do it well and do it right. Okay. And we appreciate that. All of it. Your lawyer and your insurer appreciate that. But what the Tort Claims Act does is say that even if you as an individual board member or staff person goof up and somebody is harmed because of your goof, then the what your lawyer would do if this were litigated is have the individuals dismissed. They'd have some conversation about who's responsible. Yeah. If it turns out you were just doing your job and you know, mistakes were made, then the individuals get dismissed and the action proceeds against the entity. Okay, the entity is responsible, and that's where your general liability coverage kicks in, and you know they argue about who's, you know, how much damage and who owes what to whom. Questions?
So even if you're found to be negligent, you're still protected.
Yes, negligent is it's basically you kind of didn't meet the standard of care. So it does cover negligence. Tort claims generally, and your liability coverage covers negligence, meaning that you should have done better and you didn't, or you should have known better and you didn't. What it will not cover is intentional acts, which we're going to talk about in a minute. Okay, but negligence, even to the extent it's gross negligence, which is kind of a debatable term in the law, that's what this is getting at. So the idea being that if mistakes were made, somebody was negligent. All right, if it was really a mistake, like you should have known better and you didn't, or you tried and you failed, that's negligence. Okay, so that's what we're talking about here. So you don't have to be perfect, but what I and your insurer want you to notice is the condition that you be acting within the course and scope of your duties. Okay, you're doing your job. So let's say, for example, somebody in your organization, you know, is driving the company truck and they've got a meeting with a constituent and they're going to go visit somebody, you know, and they're driving along and they, in the process of driving along, get in a car accident or run somebody over. Okay. They didn't mean it. It was an accident. Accidents happen. They were doing their job. That person is, without more, acting within the course and scope of their duties. Okay. And in that case, yeah, they goofed up. They probably shouldn't have run over somebody, and assuming that it really was an accident, like somebody ran out in front of them and what could be done, then that would be a situation where they're acting within the course and scope. Something bad happened, whether they were negligent or not, you know, to a point. And then that would be the situation where if a lawsuit ensues from that, then the lawyer would get the individual dismissed and then the action would proceed against the entity. Okay. Now, if you change the fact pattern a little bit, let's say that person goes to lunch and has 3 or 4 martinis with the buds and then gets in the car and drives to whatever that appointment is. And in that process runs over somebody. Then the question comes up, were they acting within the course and scope of their duties? Driving the car to the appointment? Yes. Drinking at lunch? Maybe no. Driving impaired? Was that within the course and scope of their duties? Very likely not. So that you can see that the facts define, you know, how liable you will be, but you can remove yourself from these protections if you're acting in a way that is not within your course and scope. You know, if you decided at a board meeting to punch somebody in the face, being, you know, having passion about something at a meeting is within your course and scope. Hitting somebody in the face about it is not. Okay, so you can see that it's very fact specific. But what we want you to take away from this is if you are doing your best, your level best, you might not even, particularly if you're new, you're going to make mistakes. Okay, it's going to happen. But this protection is there for you. So that's the Oregon Tort Claims Act. And I want you to at least know that the state of Oregon, to the extent it can, has your back. Yeah.
So when you say it goes from the individual to the entity, that's the board.
That's the district. Yeah.
District.
Yeah. Individual board members can be sued as well. Yeah. And the board collectively. But what the liability is incurred then to the corporate body, you know, the entity itself. Yeah. And that's what's insured. Yeah. Okay. And also the other protection that's available, not to the individual, but to the district itself, are the tort claims damage caps. So bless you. So there are, and there is a public policy interest in making sure that if government messes up, that they don't get, you know, go bankrupt in the process. Okay. So the damage caps are there. They change every year now. They didn't used to, but now they do to keep up with inflation. And these are the ones that are in effect from July 1. They basically every fiscal year they will change. So just by way of example, the state has higher ones and we're not concerned about those. Where you guys have the caps is in these local government ones. So personal injury or death, you've hurt someone or killed someone in the line of duty. Then if it's one person suing for something that you did, then the maximum they could recover doesn't mean they get it automatically. It means they have to prove their damages, but the most they could recover in that case is this 800,000. If it's aggregate claims, like there was one thing one bad thing that happened, you caused an explosion and multiple people got hurt by it, then that is the maximum aggregate that could be recovered. Okay, so these are there to protect the district, and your insurer, believe me, is very much in favor of these. Okay, and then there's the other limits for property damage. Okay, so and they're the same for the state and local. If rather than hurting a person or killing a person, you damage somebody's property, like you did a fire training exercise and burned down the wrong house, that could be, you could very well be sued for that. But there are caps on how much money that somebody could recover in that action. Okay, so that the concept of sovereign immunity and the Oregon Tort Claims Act is the thing I want you to walk away with. Yeah.
Maybe an obvious question, sorry. So if, let's say in your example where several people were harmed, could those individuals sue individually? Like if there's 5 people?
Yes.
They could sue individually and hit that claim.
Yeah, that's a civil procedure question, and I'll just touch on it quickly because how lawyers do their work is, it's very secret and very mysterious. But anyway, yes, and that's probably what would happen, is that multiple lawsuits from multiple lawyers and multiple law firms are going to come to the district or to your lawyer, okay? They're going to get served because you did something and multiple people got hurt. There are ways to sort of aggregate those. That's your lawyer's job, is to do that. Yeah. And the judges ordinarily don't want to decide 5 different similar lawsuits. They want to decide them all at once. So yeah, there's a procedural way to do that. There's also, and then we won't lose a lot of sleep about this, but one of the changes in the Oregon Tort Claims Act underwent a bunch of changes in the mid 2000s for reasons we can get into. But one of the things that was added there was a provision that if something horrible happens, and for each person who is suing, they can prove that their damages exceed these tort claim aggregate numbers, then the judge has the ability to bifurcate those into separate actions and then apply this cap to each one so that it's not an aggregate, but very unusual circumstances, it's possible. But that's your lawyer's job or your insurer's job. Figure that out. Okay. All right. Any questions about anything we've talked about so far before George comes up and does his thing?
My morning little dance.
Yes.
Real quick, with the tort coverage, you have an employee that has a vehicle that they need to drive home.
Yeah.
So any concerns, what if they're on their way home, so they're commuting I don't know if you consider that course of
Course and scope, yeah.
and then say they run errands and so forth, and then they were negligent behind the wheel and caused a fatality or something of that nature. What, are they still protected?
That again, this is always something that is going to be very fact specific. There's going to be a lot of questions, and that's what depositions get to and so on. Ordinarily, driving to and from work counts. The debate that's going to come up is if you were on your way home and you stopped at Safeway and then you stopped and get some gas and then you went to the bank and the argument is, and then it happened in that interim, the argument is going to be, were you acting within the course and scope when you did those things? Or were you just on your way home? So I can't tell you, yes, they would be covered, but that's what your lawyer's job is to debate that and figure that one out. So it isn't automatic. Yeah. Okay. Any more questions? All right.
All right, good job.
Go next.
Good start this morning there, young lady. This is our sixth.
Sixth
It's a sixth.
and final for this year.
6 of 6. I was getting, I want you to know that I really appreciate some of the questions you were asking, Eileen. That is the first time in 6 presentations she's had to say, wait, George will get to that.
You will throw me under the bus.
I'm always segueing into her material, and I apologize to her every class, and one of these days she's going to throw me under a big bus. So anyway, Love working with her. Well, good morning again. There was a couple things that I didn't do when we did our original introductions, and I want to make sure that you know people in the room. We've been joined by two people from our, and I'm going to mess up the department now, but the senior manager back there, Dan, Dan, you want to introduce yourself and your partner there, please?
Dan Davenport with Risk Management. Not lost control.
Not lost control.
And this is Brad Eastman. He's our new risk management consultant. So we're just paying attention this morning.
Yeah, they're coming by to see what we're up to. And Brad, welcome to SCIO. You've been with us how long now?
6 weeks.
6 weeks.
Yeah, very.
And you're gonna, and for those of you in the virtual world, he's wearing a Wisconsin shirt, so he kind of fell down to grace with me a little bit. We'll work on that. And Kaylee's back there. Kaylee's with our customer service. What do we call ourselves, though, Kaylee? Member services. There we go. This is member services, helping out, doing the questions back there. So it's my privilege to work with you this morning on the board's roles and responsibilities. I can't see this very well. Maybe you can. We're going to go through a few things. Let's start off. Who are my board members in the room? Raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Great. Great. So about a 50-50 split, board members and staff. Let's talk about the board members. How do they be qualified to serve in their position? Well, under our ORSs, they must be qualified to serve in the district, usually an elector or a resident. Elector is you are registered and you have the ability to vote in your district. Most of our districts, that's how you qualify, okay? Not all, most. Some of our districts also have the additional qualification that you can be what's called an absentee landowner. Fire districts have that. You can own property in a fire district and run for the board, get elected to the board. You just can't do what? Can't vote for yourself because you probably aren't registered to vote in that district, okay, if you're an absentee landowner. We see this a lot in recreational areas, Wallowa Lake area, Sun River, some of those places have absentee landowners that serve on boards, and they travel to and from those areas to serve. So that's the main one. Volunteer public officials may hold an unlimited number of unpaid offices. I run into this every once in a while. Somebody will say, hey, you know, I live in Deadwood, Swiss Home area, and we have a water district, sanitary district, a fire district. Can I serve on all those boards? And the answer is yes, you can, as long as they're not defined as lucrative, okay? Some boards are lucrative. In Columbia County, I use this one as the example because it actually happened. We had a rural fire protection district board member run for county commissioner and was elected. When he was elected, he was challenged and he could no longer serve on the fire district board. And the fact of the matter was he could. The county commissioner's position is considered lucrative because it's a full-time paid position. So it's a lucrative board. The fire district, those guys, it cost them to be on that board, okay? So that is not considered a lucrative board, and so he could serve on both. Now, he chose to just serve out his term and not rerun, but it fell within the, that he could serve on as many boards as he wanted to. You can be compensated as a board member. Your board can have a policy that says, we're going to compensate our board members for attending meetings. The limit is under the ethics rules up to $50 per day. No matter how many meetings you have or how many meetings you attend on behalf of the board during that day, you can only compensate up to $50. Now your board can elect to not take compensation or to take less than 50. They just can't take more. You can also be recalled. It's really difficult to get an elected official out of office unless you use the recall procedures. We're going to talk about a few other things that come up from time to time, but basically, the only way that an elected official can be removed is by the citizens that put him in, by the electors that put him or her in. You're entitled to indemnity under the Oregon Tort Claims Act for claims of negligence against the board. Eileen went into that in pretty good detail already, but just remember that the key issue is this. You're not entitled to indemnity if acting outside your course and scope. Course and scope, board members, is what you function as a board member when. When do you actually function as a board member? During the meeting. That's it. That's the only time you're really a board member, okay? You are seen in your community as a board member by a lot of people all the time, 24/7, 365, because they recognize you as a fire board member, as a water district board member. They know you at church, they know you at Safeway, whatever it might be. But when you're in that role, you are outside of the board meeting. What are you really? Citizen. You're a citizen. Okay, that's what you are. You don't function at a different level. Now, we'll talk later that the board can give fellow board members more responsibility. It can have them act outside of the board meeting, but it's assigned by who? By the board. The board takes the action and says, hey, we want our board president, our board chair to represent us at this, or, you know, whatever it might be. As long as the action is taken by the board, then you have that authority.
Be very specific.
It should be, okay? Hey, I always love this part. Thank you. Remember who I am. I'm George. I'm a practitioner. I'm not a legal advisor. I've read the laws. I can tell you what the laws say, okay? But I'm not going to give you legal advice. But I will give you practical advice. And that practical advice is based on, I started being associated with fire district boards in 1969. Don't do the math, okay? But I've been around, I've seen it. I tell people like you and even the people out there in virtual, hopefully they'll get a kick out of this. I could write a book and never have to embellish anything. I could just say, this really happened. I wouldn't give the district name or the district individuals, but I've heard it. I've unbelievable what I've heard. All right.
George,
Yes.
when the board authorizes a single board member or a couple board members to do something, does that have to be a motion or a consensus?
It can be either, in my opinion, as long as it's recorded in the minutes. Yep. I've seen it done both ways. I think the more formal you do it, the better, personally, but I've seen it done both ways, but it always needs to be recorded in the minutes. Yeah. It just can't be one board member saying, well, remember when the board did this? No, let's go back and look at the minutes and see what they really said. Okay. Make sense? Go ahead.
This may be off in the weeds, and so the $50 a day compensation. So the board can't make policy that exceeds that.
No, my understanding is it's $50 per day. No matter how many meetings or however much you're involved in. Yep.
What if there's a situation where the board member does a job for the district?
That's different. That's
different.
If the district's employed them to do something, that, you know, outside of their role as a board member, outside their staff role. Yeah, then there could be something. Yeah. Kaylee.
If a district has an official event and requires attendance of board members, such as presentations, ribbon cuttings, etc., would that also count as a day of recording?
It could. What the question was, for everybody out there, if a board member attends, on behalf of the board, attends an activity, community event, is that what you said, Kaylee, or something like that, on behalf of the board, could that all be considered? It's all about the policy. Remember, I told you it's $50 a day by ethics rules, okay? But it's a board policy that defines how that $50 up to 50 is going to be utilized. I saw something happen in my county where a board member, anytime he or she did any activity for the board, they recorded it and they turned in requests for compensation for it. So if they went on their own, they went to a city council meeting and they said they were representing the water district or whatever it was, they turned in a slip. Well, it wasn't authorized by the board in their policy. So he or she didn't get compensated for it. But if it had been, then it'd been perfectly fine. Okay, is that, I lost Kaylee. Okay. All right. You can be found personally liable for repayment of unlawful expenditures of public funds. If for some reason your board and or you as a board member take action and spend public funds that's inappropriate, the one that's public money, then you could become liable to pay that back. The only one I'm familiar with in my career is a situation where for some reason, this is years ago, back in the 70s, a board decided that they needed to get involved with a political campaign and made a contribution as a board to individuals' political campaign. I love the way you're looking at it. I don't know what they were thinking, okay? And it didn't take long for them to have to look at the pocketbooks and pay that back, okay? But that's the only one I'm familiar with. You could get in a situation, in the budget situation, where something wasn't appropriately budgeted or spent on something that was inappropriate. Very seldom does it happen. Kaylee, are you looking at me? Okay, good. Can become eligible for, I don't like the way she said that. Anyway, can become eligible for public office if a member of or affiliated with any organization which teaches the doctrine of or advocates the overthrow of the government of the United States by force or violence. That's the key, by force or violence. We can all disagree with the federal government from time to time. Nothing wrong with that. It's the American way, okay? But if you're a member of a group that's advocating to, have a civil war, you might say, against the federal government, you probably can't serve on a public board in Oregon, okay? If you're convicted of an infamous crime or any offense involving the violation of the oath of the incumbent while in office, we get this question from time to time. Most of our districts board members run for election in odd years, meaning odd years. In 23, in May of 23 will be a board election for most of you on a rotating basis for your boards. It seems like every time that election comes up, we'll get a call from somebody going, hey, George, we've had somebody apply to run for our board and we know that person was convicted of a felony. My answer to that is, are they serving on your board now? No. The answer was no. Did they pay their debt to society? Do they have the right to vote? Yes, they can run for your board. Okay. Just because somebody was convicted of a felony when they were 19 doesn't mean at 50 they can't run for your board. Okay. Now, if you, as a board member, are sitting on a board and you get convicted of a felony, you can be removed from the board through the judicial system. Okay. That's different. That's committing a crime while you're in office. Okay. You refuse to neglect to take the oath of office or to give or renew an official bond of the incumbent or to deposit such bond within an appropriate time, you can be unseated. Again, these rules, they have to be challenged to a court system, not just the board deciding you didn't take the oath. Judy did not take the oath. No, somebody has to challenge that to a court and the judge says, yep, Judy didn't take the oath and refuses to. Okay. Has an election or appointment declared void by a competent tribunal? I used to get a real rise out of this because I actually got this phone call. I had a board member call me up and go, hey, George, we heard you say that a competent tribunal can remove somebody from our board. Well, 3 of us board members think this guy's nuts. No, the 3 of you are not a competent tribunal, okay? A competent tribunal is a judicial system, mental health system, somebody that has authority to rule on that, not 3 fellow board members that think I'm crazy, which they may be right. Okay? But if you are found to be mentally diseased by a competent tribunal, you can be removed. I was involved in one of these one time where a family was dealing with a loved one that was serving on a board and really felt that that person needed to get off that board, and the person refused. They still had their competence to refuse, and they worked with a mental health industry to get the person removed. It was a tough deal, but it was the right thing to do. Kaylee, do you have something? Good. All right. If you cease to possess any other qualification required for election, and this is the one I love. This is actually in the Oregon Constitution. Article 2, Section 9, agrees to engage in or does engage in a duel or curry a challenge to a duel to another person. Okay. Now, I think we get it. Guys in my age group, we remember the TV shows where somebody would challenge somebody to a duel and they paced off so many steps and all that. That was a duel. We got that, right? Here's one for you to think about. You got a heated discussion at a board meeting. Remember, I don't have to make this stuff up. Heated discussion at a board meeting. Two people get pretty heated discussing something. One of them says to the other, maybe we should take this outside. And the other one person says, yes. Are they off the board? Could you challenge that discussion? If you guys are going to act like that, we can get you removed from the board. I don't know, but it's in the Constitution. Okay. I thought that was pretty interesting. And that's still there. Just like horses have right of way, that's in our Constitution somewhere. That's what I was told anyway. I haven't read that part. All right. Board members, how do you make decisions? Hopefully you make decisions at board meetings. That's where the decisions are supposed to be made. All right. And we have really 3 processes you use, 3 formal things you use. One is very informal, just regular voting procedures. It affects day-to-day operations. It's recorded in the minutes. No other documentation necessary. You approve your minutes. You accept the financial report. You tell Sally to go attend the board training at Chemeketa. Okay. You may actually make that a formal motion, move it, second it, vote on it. It's recorded in the minutes. That's all it requires. You probably do that every meeting. You're all involved in something like that every meeting. You also have the ability and should be doing resolutions. Resolutions are more formal. They can be done at one meeting. 2 resolutions that you're probably doing, one of them I know you're doing, every year is a resolution to adopt your budget and impose a tax or fees. Fair? There's a very formal resolution. Another one is, and I know in ORS 478 for fire districts, it's required that in July, the first meeting in July, they have kind of an organizational part of their meeting. They elect their officers. They decide when they're going to have their regular meeting. The date, not the date, the day, the time, the location, how they're going to post their meetings, how they're going to notify people that they're going to meet. That's all done, and it's all done by resolution. This is a one-time thing, once a year, and they do it. Now, I've had members of boards get back to me and say, gee, George, we don't do that every year. It's just kind of assumed, we've been meeting at 7 o'clock on Thursday for like 40 years, okay? Or the third Thursday. Okay, I get it. But if you really take a look at your enabling legislation, it probably says in there you're to do that annually, okay? And all of our districts are a little different, okay? I get challenged by that once in a while, but again, that's why I started using the word generally, okay? Look at your enabling legislation. Any questions on that? Resolutions. One meeting should be agenda size that you're going to have that action, and you can take it at one meeting, okay? An ordinance. An ordinance is a law on the people. Now it's more formal. Now you're doing something in your district that's going to restrict me as one of your citizens. It's a local law. It requires that you have statutory authority to do it, okay? To put that law into effect. And there's a very formal adoption process. I'm an old fire chief, okay? So I'm going to use what I know is true. The ability to strengthen the Oregon Fire Code by fire districts. The Oregon Fire Code gives the authority to local districts to make rules, fire code rules, more restrictive, not less, okay? Let's use one that's pretty simple to understand. A fire district can decide, look, we don't care that the state allows fireworks. We're not going to allow fireworks in our district. Do they have the authority to do it? Yes, they do. Fire code gives them authority to do that. Do they have the ability to enforce it? Should be another question, okay? When we looked at a change in the fire code in the fire district where I was chief, we had to work with the sheriff's office and the city police departments to figure out how we were going to enforce a change. It wasn't fireworks, it was actual backyard burning, okay? But we had to figure out how we're going to enforce it because our firefighters, it was going to be hard for them to do it because of their call volume, okay? Anyway, we worked that all out and it happened. So you got the authority to do it and you got a way to enforce it. All right, so that's number two. It's very formal how you go about it. Let's talk about how you go about it. This is a resolution. I kind of already went over this. Next year, I'm going to get this slide in a different spot. But resolutions, one meeting, very simple. You've got to make sure it's in your agenda and you got to make sure that it gets approved by the majority of the board. Let's talk about resolutions. An ordinance, a non-emergency ordinance. You want to change the fire code. You want to impose a fee or something. Okay, go.
I got a question about resolution. It says, in the past, policies have been adopted by simple motion instead of resolution. Do we need to fix it? If so, how?
It's, I'm going to leave that to Eileen. I've seen policies, as long as the policy's there, but the question was, do you have to have a policy by resolution? It really is a resolution. The policy is the resolution. That's the way I look at it. And I've seen, because the policy's there, people can read it. It's read by the board. They move second and it's recorded in the minutes. Eileen, do you want to comment on that?
Yeah, I guess the only thing I would add is it is a little bit, there's no requirement that you have like a thing that's titled resolution.
Stand by, she's coming up. Exercising.
And the question is, do we have to have an actual physical resolution or can we just vote on it? It is binding either way, right? That works. The issue is, in my opinion, comes down to the formality of it. When you are, let's say, for example, somebody 20 years from now wants to find out what the policies of your district are. In my opinion, the formality of an actual written resolution is extremely helpful for historical reasons and that it's clear, this is our policy, this is our policy, this is our policy. Alternatively, you end up having to go through all the minutes and figure out what your policies are. So there's the kind of the gravitas that comes with actually having a written resolution that the board adopts formally. So personally, I like to see that level of formality because it demonstrates that the board has gone through the necessary conversations. They know what they're adopting. It's specifically stated in the resolution. The resolution has a bunch of sort of whereas and, hoity-toity language in it. Well, yeah, mine don't, but they do. But they give context. They give the reason why you're doing it. They are specific about what it is you're adopting. The tricky part about just doing it by vote is somebody might have to go read your minutes and be like, well, okay, I think they said that they want to approve this. And it's harder to figure out what your policy actually is if you do it that way. Either way is legally binding. Personally, for something formal, like an actual policy decision, like you're adopting a policy, personally, I like to see my clients do it by resolution just for the formality that it is assigned to it. But I hope that helps. That's my personal point.
And I don't disagree with that, but I'll tell you how I don't want to say got around it. She'll tell you the get around fire story later. But we made sure our policies they had a date of adoption, a date of any revisions, and they were signed by the board president and attested to. So you could go to our policy book and see when that was last dealt with.
Yeah.
So you didn't have to go through the minutes. Now it was recorded in the minutes. Same thing, like she says, hers is more formal than ours was.
Yeah.
Fair.
Well, I don't know. If you have a policy book and it has the written signed policy in it, then that can be done in the form of resolution. So I think we're saying the same.
Yeah, I think there too.
Okay. Carry on.
Sixth class, I've got this down. Thank you. All right, Kaylee, that take care of that one? All right, so let's talk about how we do it. We've got to notify. It's very formal. It's a non-emergency ordinance. It takes some time, okay? You're going to notice published in the newspaper, and this is what it actually you need to publish this notice. It's not just notify the press, which Eileen will talk about when it comes to meetings. This is actually, you're putting a formal notice in there. You're buying the ad. We're considering an ordinance to impose no fireworks in our district. Okay, we'll just use that one. 4 to 10 days before the meeting, stating the time, date, and place of the meeting, giving a brief description of the ordinance to be considered, and stating that copies are available in the district office. It may also be posted in 3 places within the district at least 10 days before the meeting, or published by radio and television 10 days before the meeting under the same thing. So you may also do it this way, but you have to publish it in the paper. Okay. Paper of general circulation. Now, what's the question we always get asked? George, we don't have a paper of general circulation. Crescent, sorry, Crescent, you don't have it, okay? What do you have? Oh, we got a question from Eileen.
I just add that if you don't have a local newspaper that is a general circulation, what the statute allows you to do is then you bump it up to the whatever is circulated within your county.
Oh, county?
Yeah.
Perfect.
So if you have a local one, or in the absence of that, something that's circulated.
Perfect. I'm glad she mentioned that, because I can tell you that there's a newspaper in our county, Columbia County, I know Mark's from Columbia County, that's making a living on these things, when they're required to publish. They actually put out a section now. The paper comes out once a week, and it has a section that's all legal notices. So if you want to know what the legal notices are in Columbia County, you go to the Spotlight on Friday, and they're there. See it, Mark? There's more news in there than in the regular part of the paper. Okay.
Is publishing it on your website, does that count for one of these?
It counts as one of these postings. It doesn't count as the publication. Now, for your public meetings, which she's going to talk about this afternoon, that's different. That's a notice. That's not a publication. This is actually a published. Okay. Must be read during the regular meeting of the district board on 2 different days, at least 6 days apart. You can't approve an ordinance at one meeting unless it's an emergency. And we'll talk about emergency in a second. But you have to do it at least 6 days apart, and they have to be read, and we'll talk about that. Kaylee.
Question saying, you have to publish in the paper a revision to an ordinance.
Yeah, if you're revising an ordinance, you're actually updating it, and that goes through the ordinance process. Yep. Did you everybody hear that? I should repeat that. The question was, if you're revising an old ordinance, updating it, do you have to publish? Yes, so it's the same. Okay. Sir?
What is it posted in 3 public places? Does that mean physical location?
Yes, a lot of districts.
Like the 3 telephone poles?
It used to be telephone poles. They won't let us do that anymore. But when I was a kid, man, that's how you got your news, those telephone poles, okay? Your district should, once a year, should announce, hey, we're going to post something, post our meeting notices, whatever. Here's where we're going to post. One could be your website, okay? One could be the front door of your building, a particular building, and one could be someplace else, you know? You let people know, though, once a year where you're going to do that. And you always do that when you're posting, when you're giving notice, okay? All right. The ordinance must be read during regular meetings of district board. Oh, I said that. Reading must be full and distinct unless at the meeting, a copy of the ordinance is available for each person who desires a copy, and the board directs that the reading be by title only. I use the fire code as an example. When you are passing an ordinance fire districts for the fire code revision, you're actually going to publish the whole fire code. It's like this. You don't want that read at your board meeting, okay? You only want read the title of what you're changing, what you're doing, and you want a copy available to anybody who wants to really get into it, okay? That's the way you want to do that. Otherwise, you're going to start your meeting at Tuesday at 7 o'clock and you're going to finish it on Thursday, okay? You don't want that. Requires affirmative vote of the majority of the members of the board. Eileen's going to get into this quite a bit this afternoon, but I can't emphasize enough. Ordinances, resolutions, action taken by the board generally, almost always, is by a majority of the board, not by a majority of those present. Okay, it's a majority of the board. So 5-member board, 3 are present. What's the vote got to be? There you go. Within 7 days after adoption, it's signed by the presiding officer, it's attested to by the recording secretary, and it's recorded in the district files. Question? Sure.
On the posting of notices,
Posting of notices.
website, on your office, does Facebook page qualify?
You know, I think it does. I personally think it does. Now, I will tell you, and she will tell you this afternoon when she really gets into this, okay? Don't be looking back there. You get to look at her all afternoon, okay? She's going to share with you really what that is. But, you know, she makes a comment, and I have to use it because I just think it's our lives is not caught up with technology. And I see a lot of things happening on Facebook and some of this stuff that districts are using that, I'll be honest with you, that's where my wife gets the information. My wife will come to me, and God bless her, she'll say, hey, did you know that there's a new subdivision going in down the street? No. Well, I saw it on Facebook. And it actually came from the city. It didn't come from some person down the street. It actually came from the city. So practitioner, legal. All right. This one here, I got a little story about this, but I'm not going to take up your time. A certified copy filed with the county clerk available for public inspection. A certified copy. I get that question. What's a certified copy? Well, I didn't know. We passed an ordinance at Columbia River Fire and Rescue. I did these things with my staff, make sure my board president signed it, board secretary. I took 2 copies, two wedding copies, you might say, down to the courthouse, and I said, hey, I'm required to give you a certified copy. How do I do that? The county clerk goes, no problem, George. No problem. Give me those. She takes them. She puts a little sticker on them. She put them in a stamp machine. Click, 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 click. Handed me one and put one in her file and said, you're done. Good job. That's certified. Okay. And why do we do that? Why are we required to file our ordinances, not our resolutions, our ordinances with the county clerk? Public access. Public access. You move into Columbia River Fire and Rescue, you move into Columbia County, you can go to the courthouse and say, hey, I'm thinking about buying this piece of property. Can you tell me if there's any special laws that apply to that property? And they should be able to tell you. One-stop shopping, okay? Didn't have to go to the water district, didn't have to go to the fire district, didn't have to go to the library district, went right to the clerk. There's a law on me, it's there, a law on my property, okay? That's why. Unless referred to electors takes effect 30 days after it is adopted, unless a later date is given in the ordinance. You can declare in your ordinance you want something to take effect blank, okay? Fire districts, you have the ability to limit who runs for your board by ordinance. You're one of the very few districts that have that ability. You can limit volunteers in your organization, staff people from running into your board, but it has to be done by ordinance. Columbia River, do you have that in place?
I know volunteers can.
Yeah, generally it included both. I'm pretty sure you do. That's why I asked you. But that one by statute, by the rule that applies to that ordinance, takes 1 year to take effect. You can't do it quickly. You can pass it, but it's a year later before it has, because it gives time for people that maybe already be on your board to decide which way they want to go. Do they want to be a volunteer? Do they want to be a staff person? They want to be on the board, and people to run to decide whether they want to run or not, whether they want to stay in those positions. Okay, so some ordinances take longer. There is an ability to have an emergency ordinance. Kaylee.
Is a certified copy filed with the county clerk required for any ordinance?
All ordinances passed by districts. Yep. Now, I will tell you that the person out there that asked that question, are they required? The answer is yes. I will tell you that the county clerks will tell you that they don't have them all, because you haven't done it. There's no teeth in that. There's not the ordinance officer out there looking at your districts. But there's a good dang reason why the law exists, and we already shared that with you, okay? All right, you have the ability to do an emergency ordinance. Here's the key. Must state the nature of the emergency. It better be a real emergency for you to invoke a law on the people like that, okay? But you have the ability to do it if you have a real emergency. I don't know what it would be in most of your cases, but it could be. There's a situation going on right now, and maybe some of you water people are aware of it, in some city in our country that's having a big water issue because of a flood.
Jackson, Mississippi.
Jackson, Mississippi. I don't know the whole story. I just heard it on the news this morning, but they probably got some emergency going on there that maybe they didn't think was going to happen. Okay, that's not good. Anyway, it can be done at a single reading, a single meeting. If it's a true emergency, you can even call an emergency meeting to deal with it. Takes effect immediately. Must state the emergency requires unanimous approval. All board members have to vote yes, not the majority that are there. Majority of the board, unanimous. Has to be unanimous if it's an emergency.
So if one board member is absent.
You got a problem. You need to find that person, get them on the phone. You got a problem. Okay. Yeah. Go. You don't. She's gonna.
Well, I believe the way the statute reads is in a unanimous vote, a quorum being present. So the idea in that situation is at least.
Oh, okay. I got it.
The quorum has to be there, but everybody else, even if it's just a quorum, it has to be unanimous of everybody who's there. That makes sense. There's one rare time when you can do it by just whoever's.
Okay, I'm sorry. I didn't read it. But where I got hung up on it, I still am. We always say that if it's a quorum present, it has to be unanimous. So if you're a 5-person board, it's 3, right? But what if there's 4? This tells me that it has to be 4 of them. And she agrees with me. Does that make sense? So that one can be absent, but the 4 that are there better all agree. Okay. All right, good. Thank you. Any questions on ordinances? Here's my final practitioner line on ordinances. If your board is considering putting a law on the people and you've researched it and decided, yep, we have the authority to do that, you check with your district's legal counsel. You get your district's legal counsel to help you draw up that ordinance. Make sure you do it right, because I guarantee you, somebody out in your community isn't going to like the fact that you're trying to put a law on them, okay? Even though you have the right to do it, even though you have the right charge of it, even though the right to have, you can restrict burning, okay? I know from experience that people didn't like it when we restricted burning in our cities. It was the right thing to do, and it's still in effect today, but there was people that, they were not happy, okay? Because they love them burn barrels.
George, I
Yes.
was just curious, I work for a small conservation district, so we're not regulatory, but
Right.
just a question out of curiosity, I bet if you don't file with the county clerk, then it would be hard to enforce that ordinance.
Correct.
Okay.
Yeah, if you had the right to enforce it, which I'm sure you did, or, you know, you're, like you say, you're non-regulatory. Although soil and water conservation districts, they're one of the reasons that I'm very cautious of what I say, because they're an odd duck. I mean that in the most positive manner. They came from, they actually grew out of the Oregon Department of Agriculture. They weren't created like the rest of you. They just kind of, the Oregon Department said, oh, we're going to create these things. And they became part of us, which they're great districts. They do great work, but they're very odd on how they're set up and how they're appointed and all that stuff, budgeting, the whole thing. All right. You heard Eileen say this morning that she gets on her soapbox once in a while. Well, a bunch of us that do work in the consulting services and have done work with districts like you for years started looking at districts going, how come District A just seems to roll along, do good things, get good press, has very few issues pop up, and Districts B kind of struggle. They seem to always have chaos, always have something going on, you know, they have us on speed dial, okay? So we really started looking at it, not to be critical of either side, we really started looking at it, and we said, what did the districts do different than the other districts? And here's some things we came up with, and I was just gonna, it's kind of my soapbox, okay? Number one, the first slide is they have a clear understanding with their board and their staff of vision, mission, and values. They get together and they talk about what's the vision for our district? What do we agree we're going to strive to be? How do we want our community to see us? And they talk about it. They may not be there today. They may not be where their vision's at, but they have a vision to get there, okay? And they all kind of agree, yep, that's who we want to be. We're going to strive to get there. Mission, what does the district do? Why are we here? What services do we provide? Are we providing the services we're supposed to provide? Are we doing some we shouldn't? Okay. Or is there some we're not doing that we should be doing? What's our mission? And they actually look at it from a standpoint. I've gone into districts, and one I always like to brag about is Sisters Camp Sherman Fire District over in Sisters. When you walk into their building, it's obvious that they have a clear understanding of their vision, mission, and values. And they have values they operate by. Why? Because they're posted. Everybody can see them. They every couple of years, they take a look at them. Does that still apply? You know, does it need to be tweaked? But they put them up. They're there. You go into one of their meeting rooms like this, on the wall, here's how we meet. Here's how we interact with people. If you're going to meet with us, here's the rules. You're not beat up with them. They're just there on the wall. Have you seen them? You're somewhat near there. Yeah. All right. So a good understanding of mission and a set of values, guiding principles, code of conduct, ethics, something that they do internally. They agree to. It's not imposed by somebody else. They sat down and talked about it. That's what we see from a lot of districts that are functioning at a high level. Okay. Two other things that we've seen. One, the elected officials have talked to each other. They've sat down and said, listen, in order for us to be effective, in order for us to have good business meetings, we need to have some expectations for each other. We just can't let people just willy-nilly, you know, just have expectations for yourself. We're going to talk about it and come up with some. This is some that people have come up with. This isn't George's list, but I like it. I'll just tell you that. Here's the list that a lot of them have come up with. Expectations of board members, of each other, okay, of each other. We're going to be prepared and informed about the items that are on our agenda. Not prepared and informed about everything that might come up, but by golly, if it's on the agenda, we're going to be as prepared and informed as we can be so we can be a participant in the business meeting. So we're ready. We're going to be honest and courteous. We're going to tell the truth. We're going to be courteous about it. We're going to be fair. We're going to lay it out there. We're going to be respectful of each other in the district. We're going to start our meetings on time. What did we do for you this morning at 8:30? We said, hey, good morning. Good morning, we're here. Who do we show respect to? You. Because we told you we're going to start at 8:30. Dan walked in late. Did it bother us? Heavens no. He got tied up in traffic, you know, the bridge was up or something. Otherwise, he'd have been here on time.
We didn't decide to come till 8.
Yeah, you didn't decide to let me, let's go see what those guys are doing. But it doesn't, see, we got our meeting going. We got it going, and you come in and join us, okay? Now, what's the exception to that? You're the board chair, Judy, and that you're ready to start your meeting, you don't have a quorum. What do? Hey, it's 7:30, we're due to start the meeting. We don't have a quorum yet, but we know they're en route. Just let the people know, okay? Be friendly, be courageous. What does be courageous mean? Why did board members look at other fellow board members and said, we want you to be courageous. We expect you to have courage. Why did they say that?
Because you represent body and you have to bring your voice in.
Absolutely. It's okay to have an opinion. It's okay. We may not agree with it. Probably gonna agree with 3 or 4 other things that you bring up though. Just didn't agree with that. Have the courage to bring up something that may be unpopular, but get over it if it's not the majority. Don't be the board member that's still whining about the fence that was put up in 1979. It lasted. It's still there. Leave it alone, okay? Represent board position and actions. Once a board makes a decision, represent those actions. You don't have to agree. But if somebody approached you and said, hey, what decision the board made? Tell them the board made this decision. You don't have to go into all the detail of why you didn't like it. Just the board made this decision, we're moving on. I had a fire chief that I worked with, his name was Jack Snook, but he's still around today. I was leaving a board meeting with him one night. He was feeling like he got some things done, got some things he got beat up on, kind of we're wandering down the hall of the building. He looks at me and he goes, you know, George, we got a really great board. Says the one thing I really like about our board is they never look back. They don't have any rear view mirrors. The only time they look at something that they've made a decision on is when they get information that they didn't have when they made the decision. And he's right. Boards have to make some tough decisions sometimes. Don't look back unless the facts change. Now it's important that staff bring you those facts that they didn't have. Okay? But if you're just the whiner, excuse me, and I don't mean WINE that I see out here in the, by the way, it's beautiful out there right now. Anyway, don't look out there, look at me. But unless you have the facts change, there's no reason to revisit it. We're going to go forward. And that's the way that fire district board was. Understand yours and others' roles and responsibilities. Remember, these were board members that got together and said, here's our expectations for each other as elected officials. But they didn't stop there. Who's my staff? Raise your hands. All right, staff, they didn't leave you out. Okay. They looked at their staff, their CEO, their manager, and said, hey, we have expectations for you too. We expect you to be prepared and informed about the items that are on our agenda. You're our technical experts. You be prepared and informed. If you're not, get the thing off our agenda. Let's address it another day. Let's not beat it up 3 or 4 times. Let's get all the facts and be ready for it, staff. Provide us with options. Make recommendations to us if you can. The only time I caution staffs not to make recommendations, it's when it's highly political. Who are the politicians on your board? The board, not staff, okay? Staff, be careful when it's a highly politically charged decision. Help the board, but don't make their decision. They're the politicians, okay? And I mean that as a compliment, not as anything bad. Provide us with organized board packets. Hopefully now, Eileen and I have been doing this for 5 or 6 years. Hopefully now boards are getting their information 3, 4, 5 days before their meeting. Uh-oh, I got one person shaking their head. We need to talk, okay? There's really no reason for that. Heck, I'm on a credit union board, which is similar to a public board because we're elected by our what? Members, okay? And serve at their will. We get all of our board information by electronically on a secure iPad. Comes to us a week in advance on the iPad. Now, is the credit union still working from the time they send us the packet till the time we ever meet? Absolutely. So we may get something added to it in the days coming up because it happened, something happened, okay? Like somebody tried to jerk an ATM machine out of a building, that'll get your attention, okay? But we got a week to prepare. And so there's no reason for us not to be prepared for the meeting. No reason for staff not to be prepared. Give us those packets, staff. Communicate with the staff, no surprises. I don't care how bad the day's been in the district, let us know. Because as board members, we don't want to hear about a bad day at the district where? At a local coffee clutch, okay? At church, at Safeway or Fred Meyer's. We want to hear about it from you. Okay? I've had to make those phone calls to board members. I've had to make those phone calls. We had a bad day today. Or 3 o'clock in the morning, had a bad day. They don't like those calls, by the way. Okay, but anyway, I did it. Be honest with the staff, be friendly to us, and for heaven's sakes, represent our actions. You may not always agree with us. It's okay. But once we make the decision, let's move on, because there's going to be a lot more decisions to come in the future. Okay, questions on that? Again, I call this a little bit of soapbox by me, but I didn't develop all this. I researched it. I talked to people like you, okay? And some of you may come up to me and go, hey, George, we have something similar. I want to hear about it, because we're trying to help districts be effective, run good business meetings, and get the job done for who? The community they represent, the service they provide. Questions?
So on the board packet, what, you send it out a week ahead of time, and then what if the board replies all, comments on, corrects the minutes?
No.
Yeah.
No, don't do that. Eileen's gonna get into a thing this afternoon about the use of email and all that kind of stuff, but there's no reason, when your board packet goes out, there's no reason, if you do it electronically, there's no reason to respond back. You may want to call the chief or the CEO and say, hey, look, can I come in and talk to you about item B? And I don't know how you deal with that. We dealt with it differently. I met with my board members face to face prior to the board meeting, but that was just something that we set up. Okay. They all have, someone would say, hey, George, I don't need to meet this month. I'm good. And so others would say, I'm going to meet with you 3 times because I'm not good. All right, go.
And so we have our chair that runs the board. Some chairs.
Runs the meeting.
Runs the meeting.
Runs the meeting.
Some are better than others.
Sure.
And as a district manager, there could be a discussion where I see things going in the wrong direction legally or procedurally, and the chair is not managing that.
This is where your skills.
Are we stepping in?
This is where your skills come to play. Okay. I always tell CEOs, managers, don't try to run the meeting, but have a relationship with your chair, your president, whatever, that you can get their attention and caution them about things. And I've seen boards that actually segue to the CEO. They want the CEO to take some lead on something. That's fine if they're asking for it, but be careful if you're just inserting yourself.
Okay.
Make sure you have that relationship, because I've had board members come to me and say, well, I go to board meetings, it's just, the general manager just does everything. We don't get to say anything. Well, no, you should have an opinion. You should have questions. Again, I'm going to use an example, my work on the credit union board. I've learned a lot by being on a credit union board that's different from being on a public board, but it is very, very similar. And I want to share this one thought with you. Credit union boards are basically audited by the feds. There's an insurance group that shows up and they look at all the minutes. And one of the comments they had about our board was that, your board members don't ask very many questions. Why is that? Baby, we ask questions now. Because it really did open our eyes a little bit. Like we were just letting the CEO just basically taking everything at face value, which it was value and it was the truth. And, we had good records in front of us that supported what he was saying. But now we're a little more engaged. And I think it's a good thing. There's nothing wrong with that. Kaylee.
We have a couple of questions. One individual has their hand raised and would like to ask their question.
I'm sorry, what'd she say? I couldn't hear.
Or somebody wants to ask a question themselves, it's virtual.
Okay, how do we do that? All right, does somebody have a question out there? You've been unmuted. Try again. The wonders of technology. Where are my grandchildren to help me?
Questions, we'll ask those.
Okay.
They go back to the ordinance.
Ordinance.
Yes, so the first question is, if filing the copy of ordinance has not been done in the past, can approved ordinances still be filed?
Yes. can approve ordinances that you fail to take to the county clerk and work with your county clerk. Your county clerk may deal with it differently than mine did. But yes, you can take those down there.
And the second question is, I'm trying to find info online about who to file with, whether or not any of our ordinances have been filed. Any guidance would be appreciated.
I would directly visit with your county clerk and call their office or go in and visit with them and find out who. In Columbia County, under the regime that was in place when I had to file orders, the actual county clerk came and met with me. Today, it may be one of her people that works with her. I don't know. Is that fair? All right. And my question, the one to come in their own voice, they decided, I might have answered it. Let's look at it that way. Hey, sir.
I have a question on expectation of board members of being informed. Sometimes board meetings will have a work session to inform board members of upcoming things. Other times there'll be separate meetings with staff, like 1 or 2 board members at a time meeting with staff. But if the staff person meets with all the board members, even maybe sequentially, that doesn't qualify as a meeting if it's just informational. Is that correct?
No, I will tell you that when I was assistant chief of Wildlife Fire and Rescue, there was a couple of board members that met with me every month because my division spent the money. And the chief, when they ask him a question about how come you're buying 400 batteries, you just go talk to George, you know. And so they actually came into my office, a couple of them every month, because they were curious about why we bought 400 batteries or whatever it was. Okay, so no, that doesn't constitute. Now you need to be careful. I always get in. I'm supposed to. Oh, is it 10:30? Not quite. Sure, I'm 15 minutes ahead.
You need to be back here.
Oh, that's right. God, you'd think I would have this down. In meetings, she may want to address that a little bit more with you. She talks about meetings, but I don't see that as a quote meeting. If there's 3 of them there and you're a 5-member board, that's a meeting.
Yeah.
Okay. Anything else? All right. It is 10:15. We're going to be back here at 10:30 for an hour and a half session. We'll take you to lunch. Okay, hold it.
Before you go, we'll get into this. I found this out, there's currently no water to the building. They tell us it's temporary, they're doing some maintenance, that you can use the facilities, you won't be able to flush. And there is currently no way to wash your hands. Just FYI, they tell us they think within the hour everything was stored, but just before we went to that, you should know.
Could they go to a different building? We don't know that.
Yeah.
It's the whole facility.
It's down to the whole-
So we can blame the city. All right, let's go on break.
Hey, little tiny towns, so low.
Yeah.
Before the city is like inbox unopened or something. Okay. Right, yes.
There's no water.
Yes.
Oh,
Oh, and so enjoy this.
No.
I was a teacher. Right.
I also worked.
That's what the daughter is.
Yeah.
Students. She started at 7. Yes, I have. The reason I think this is how you want to. So I had to talk to. What brought you to work? Besides
My wife's she's grown up. Most of the
The weak moment there. There you go. I'm okay with that. I just buried my good friend in Cumberland. She lives on the street. 3 years old. But on her 80th year, and she's 4 children. She was, well, that's nice. But it was speaking to and asked why everybody was represented. Yes, in 2 years. But she had very specific instructions. I've been around. We're young.
We sort of are in the valley. I was just.
We were pretty.
It's like every time you do
Now, Todd. Should I use our board?
Yeah, no.
Hello? Hello?
They get on the board and then the police start. It's too
I don't understand.
You'll get it.
Just scared of it. Water and you see, you know, he just, we have a very dedicated. That's.
But it's always really complex when you have board changes, they get the musical. Decided retirement to switch from water to water.
Hello? Hello?
Even though we don't say it's, so I was kind of there representing pt.1, saying that the Alabama level is good. They're all under a 190. So.
Mute your speaker.
Let's kind of. We're risk management is our technical focus.
Yeah, but I'm not.
I have 2 meetings here.
Legally speaking.
Good job. Something like that.
And I.
Oh, you do?
Not enough is employees.
So I'm just for.
See what you probably don't want
We got 3 hours. She got the same.
Good line, guys.
Okay, everybody, come back. Sit down, shut up.
Yeah. The only thing I can do with that,
The online person has their hand raised.
you said this.
Sure. Somebody has their hand raised online or on the virtual, okay? Okay, yeah, let me get the crowd noise down a bit and then we can try that. Okay, welcome back, everybody. We're gonna start. I understand there is still somebody online who wants to ask a question. You might have to unmute. Okay, well, keep trying. We're here for you.
You can also type the question in the chat box.
Oh, okay. Do you want to tell us what it is? Or,
We can ask them maybe to type it in the chat.
ask them. I thought you said they did. Okay, sorry. Yeah, whoever has the question that you want to ask, for whatever reason, we're not hearing you. So you can type it into the chat box and Kaylee will pass it on and we'll try to get it answered. Okay? And thanks everybody for your patience while you work out the gremlins. And I hope the lack of water isn't a long-term problem. One of the things, there were a couple of people at the break who we talked about and rightly called me out on something that I said earlier. And I want to clarify because I answered something very quickly in the interest of time that needed more clarification. Filing a lien for an unpaid water bill is generally not allowed. The question came up from the audience, and there are legal reasons for that. Legally speaking, the contract for water service is considered to be personal between whoever's the water provider and whoever's the account holder. Okay, so it's contractual. It doesn't tie to the land. And most of the time you can only file a lien on a piece of property when you're providing a service that is associated with the land. Sewer service, for example, you can file a lien for unpaid sewer on the property itself because it's tied to the property. It's not a contractual agreement between the account holder and the provider. So you don't have to get lost in that wonkiness. I did answer something very quickly and there was a couple of people rightly called me out, like, I thought we couldn't file a lien for unpaid water. Most of the time you can't. There are ways to collect and most of the time the solution is to turn the water off. but it's kind of a more complicated answer than should be answered that quickly. So I apologize, and for clarification, don't file a lien for unpaid water unless you get legal counsel on whether you can do that or not, okay? Hopefully that clarifies a bit. There were a couple people who wanted to talk about that at the break, so we'll do that. All right, so this next segment is admittedly very basic, all right, and it's on purpose. We don't want to get into public finance. There are people who know way more than I do and about financial stuff. That's not my thing. But my reason for including this section in here is primarily for those of you who are new to public, local government stuff. And also those of you who maybe have heard some terminology and you're like, I'm not sure I entirely understand how that works. So I thought just a basic review of public finance and the way it works might be helpful. So this is admittedly short, but I'm just going to walk through some basics with you. And in the area of finance, of course, we're going to review the law like we do. I can't even read my own slide up here. What's that say? We'll talk about methods of district financing. We'll touch on local budget law. And we'll talk about the municipal audit requirement. We talk about methods of district financing. The primary one, most special districts are funded with property taxes. Okay, we'll talk about there are other options, but primarily if you're funded by property taxes routinely, you have what's called a permanent tax rate. Was anybody involved in this local government stuff in the mid-90s when Taxpayers United and Bill Sizemore and in that whole, the property tax system underwent major changes in the mid-90s. And there was a big movement, taxpayer movement. The feeling was that government was getting way too much money through property taxes and something needed to be done. So there were a bunch of changes that were made by initiative, and they were changes to the actual Oregon Constitution. So if you went to look at Section 11 in the Constitution before 1995, it was, this long. And now it's like this long because a bunch of stuff was added to the Constitution. So, another little soapbox that I get on when I have the time, and I'll just do this here. The fact that Oregon has the voter initiative option, like your average Joe can put an initiative on the ballot. That's great. Sometimes it comes from the legislature, but it can also come from voters. And there's nothing wrong with that. Citizen initiatives, cool. And one of the things that makes Oregon, Oregon. However, be very careful if you are looking to vote and something says amends Oregon Constitution. You don't have to amend the Constitution to make a law. You don't have to do that. But proposals to amend the Constitution, always stop and think about that, because once the Constitution is amended, it's very difficult to unamend it. All right, it's much harder than just to change a law. So to think carefully before you vote yes on something that amends the Constitution. It might not be necessary to do it that way. So that's my little soapbox. So this was one of the examples where the Constitution of Oregon was amended substantially in the area of property taxes. And at that time, in the mid-90s, what the new changes said was that you are assigned a permanent tax rate. They used to calculate property taxes differently, and it was calculated. Now it's calculated this way. Whatever tax rate you had at that time became permanent. The property values were frozen at 1995 rates, less 10%. So at that time, whatever your market value was frozen, and then it was less 10%, that became your assessed value. Okay, so if you went to look now, the market value is whatever you can sell the property for. You're going to list it for sale, the more the better, right? That's how you sell it. That's the market value. In this case, we're talking about the assessed value, and the county assessor's job is to figure out what the assessed value is. And the reason we have an assessed value, so we can figure out how much tax you're going to pay on your property. Okay. So at that time, every government entity that taxed was assigned a permanent tax rate, okay? And it was whatever it was at the time, and it was made permanent. So it is permanent in the sense that you're stuck with it, all right? And it is based on the assessed value. So it's so much per thousand of assessed value. So you look at the assessed value and you say you are authorized to assess 25 cents per thousand. You add all that up for all the properties in your area, and that is your property tax income based on your regular permanent tax rate. The value, the assessed value, can only increase. It can increase no more than 3% per year. So there's a cap on how quickly that value can rise. And the associated permanent tax rate revenue. This is a little bit misleading, but it's not that the tax rate doesn't change. But the fact that the assessed value can increase up to 3% per year, then the amount you can collect will increase accordingly, okay? Because it's based on the assessed value. So that's a permanent tax rate. That's where most of you are getting your tax revenues from. There is another kind of, yes.
A question on the values. Now, 3% per year, that's maximum, but what if you have a huge industry and Intel gets built and it goes over that 3% because of that building? Is that?
It is highly unlikely to do that because remember, we're talking about the assessed value, not the market value. Okay, and the county assessor does whatever math they do to figure out what the assessed value is. So the assessed value of any property is not allowed to increase more than 3% per year. The fact that another entity, another big industry has come in, we may affect the market value. It may drive it up or down, but the assessed value is going to be property by property, and it's going to depend on that new industry is going to have to pay their own property taxes based on whatever their assessed value is. How that is determined, I don't know. I don't want to know, but that's what your county assessor does. Okay, so that's a permanent tax rate, and then there's another form of property taxes called the local option tax. You'll see a local option levy, also another additional property tax that can be assessed, but this one is not permanent; it's temporary. You have to go back to the voters and get it approved. If it's for operating revenues, which most of them are, a lot of fire districts fund their staff this way. Every 5 years, they have to go back and get the voters to approve the new levy, okay, local option levy. If it's you can get one for capital improvements, which is usually building something big. You can do that, but that's no more than 10 years. You have to keep going back and getting approval from voters for that. One thing about since the changes in the Constitution with respect to property taxes, any money measure now, if you're asking, if you're a government and you're looking for money, in almost every case, particularly if it's a taxing thing, you have to go to the voters and get it approved. Okay, the voters must approve it at an election. And that is true of a local option levy as well. Okay, so you have to go to the voters. And if you're required to go to the voters, that any money measure is going to be subject to double majority requirements with some exceptions we're going to talk about. So somebody volunteer for us what the double majority requirement is. If you've been around for a while, this is an easy one.
75% of the vote.
No. There's two majorities. Yes, you have a long history of experience in this area. Tell us what the double majority means.
Majority of the property owners, majority of the electors.
Yes, there's a double majority. So what that is there's a turnout requirement. So you need a majority, so 50% plus one of the registered voters have to show up and vote. And of those who show up, 50% plus one or more have to approve it before it'll pass. So there's two majorities that have to be met. The idea being, the reason why that was changed, presumably, is because there were money measures that were being approved by some small faction of people who actually voted. In my opinion, if you're not voting, then you get what you get. But, I'm a big fan of elections and voting and making sure that people have a voice. Yes?
Question is, it is my understanding that the double majority requirement only applies.
I'm going to talk about that. Hold that thought. Let me finish my thought first. Yes, we've done this before. Yes, and as I said, there are exceptions which we're going to talk about. There didn't used to be. Okay, when it was initially adopted, it was double majority all the way across the board. Any election, double majority. And what happened in reality, because this was in the Constitution and it was very hard to change it, was that local governments were kind of being starved for cash. I mean, they were in a position where they couldn't fund their operations because they couldn't get enough income to do that. Okay. That the actual ramifications of the tax law changes started to be felt at the local government level. And so what happened was the legislature went in and by law tweaked this a bit. And what they did was initially it was just the May or November elections. It eventually became May and November election during presidential election years. So it was kind of like the May primary and the November election were exempted from the double majority. The turnout requirement didn't apply. And the idea in those is that that's when people tend to show up and vote, right? Oregon has 4 elections in a given year. The May and November, which we all kind of know about, but there's also one in March and one in September. So March and September are usually, people are like, nah, I didn't even know we had elections then. They don't tend to show up for those. But they do tend to show up for May and November, particularly during a presidential election year. So, so that was the initial change. And then it was changed again after that. So now that the voter turnout requirement doesn't apply at any May or November election. Instead, it's however many turn up, the majority have to approve it. But if you're at the March or September election, the double majority requirement still applies. Okay. So keep that in mind. And also, because it is a property tax, it's subject to compression. I won't ask anybody to explain that. Sometimes we get somebody in the audience who's like eager to tell us all what that means, but it's a fairly complex concept, so I'll try to sort of boil it down. If you go to the Oregon Constitution and you read what it says is that, and this one is based on market value, which makes it even more complicated. But what it says is that there is a maximum, if you took, let's say, a hypothetical area in which taxes are being assessed, okay? Just imagine a boundary, if you will. And within that boundary, what we do is take all of the taxing entities that might be imposing a property tax, whatever special districts are there might be a city, there might be a county, a regional government, there's a bunch of bodies that are assessing a property tax. So we add all those together and the amount of tax that's being assessed in any given property, okay? According to the Oregon Constitution, that aggregate amount of money can't exceed $5 per thousand of market value for education. And if you took general government and added it all together, not schools, but everybody else, that can't exceed $10 per thousand of market value. So there's this analysis that has to happen because the idea behind that one, presumably, is we're going to cap how much overall tax can be assessed, okay? And if you are, for schools, at exceeding that $5, or if you were for general government exceeding the $10, then everybody is put into what they call compression, which means that the ability to collect your taxes is capped, and everybody gets to collect, something less than what you're otherwise authorized to collect, because there's a ceiling on how much aggregate tax can be assessed in any given area. Okay, so because these are property tax measures, they're subject to compression. It might not be any big deal if you're in an area that doesn't have a lot of taxing entities, but you sort of see it in special districts almost by definition are outside of cities. Cities provide a lot of these services, but special districts occur elsewhere. So you might have a fire district and a water district and a sanitary district, and they're all providing different services and they're all assessing a certain amount of tax. So the potential is there that you're going to bump up against those maxes. And where I have seen it in my practice is sometimes I help districts form, like help communities create new districts. And if they want to assess a permanent tax rate, then what we have to do is go to the county assessor and figure out if we want to assess X amount, is that going to put us into compression or everybody else into compression? If it's us, then we have to recognize we're probably not going to be able to collect everything we want to. And if it's going to put other people into compression, we're probably going to get a little bit of a resistance to our formation because they're like, heck no, don't take our money away. So it affects the overall amount of tax that can be collected. So those are the property tax, and that affects property tax revenues, okay? Another common form of public finance is coming from fees for services. So, and you see this primarily with like water districts and sanitary districts, the ones who you pay your bill every month and you get the service in exchange for that amount of money. If you have the authority to charge a fee, it will show up in your principal act. So you want to go look at whatever that chapter is that authorizes your type of district, and it'll say something like the board has the authority to adopt rates and charges, or it'll say that in there. If you don't have statutory authority to adopt fees, then you probably can't do it. And not every type of district can do that. Water and sanitary is the obvious one. Wastewater is another one. Soil and water conservation districts, for example, don't really have any authority to adopt fees. They have the authority to do other kinds of things like grants and certain sort of contractual relationships and so on. But in terms of assessing a fee, they don't have that kind of authority. Fire districts have a very limited ability. That is, since I've been in this area, they didn't used to have any authority at all. And then there was a big lobbying effort, I want to say like in the late 90s, to change the law so that there is some ability to collect fees. I think from some, you can correct me if you're a fire person, but I think plans review, certain inspections, I think, ambulance services, certain kinds of fees that can be assessed for out of district services or things like that. So check your principal act to see if you can charge fees. And if you can, again, they have to be authorized by law. They have to be reasonable. And what that means is anybody's guess, but what it generally means is that there has to be some kind of business-based reason for the fee. Okay, you have to be able to show this is a reasonable amount of money, given that we have X number of expenses and we need so much income and we need a little bit for reserves, and you have to be able to show that it's reasonable. And then also it has to be not arbitrarily imposed. So you can't discriminate against people based on fees. You have to be applying it in an unarbitrary way. Yes.
Oh, you're talking about fire districts. So, I mean, we in our fire district, we do charge fees for people if we provide a service to someone who's not in the district.
Exactly.
And we go and we say, put out your house fire. You're right on the border, but you're not in the district. We will charge you a fee.
Exactly. That the extraterritorial services, we call that. And because then the argument there is they're not paying taxes because they're outside of your district. So you can collect contractually is really how that works is whatever you're charging them to put their fire out. Yeah, or they pay you for the knowledge that you will show up and put their fire out if they have one. Yeah. Question from the interwebs. Yeah.
Can we create a commercial class of customers for those customers who have commercial businesses in the district, such as short-term rentals, and charge these customers a commercial rate?
I wonder if the person I'm thinking of is asking this question. There's some client of mine who feels strongly about something like this, but that might not be him. You never know who's out there. Well, I can tell you that, first of all, yes, if there is a business-related reason and it's reasonable, you can discriminate between, say, commercial customers and residential customers. You have to get good legal advice to do that because it can be tricky from a legal standpoint. However, if you have a good business-based reason to do that, yes, you can. I know that the issue of rental properties, particularly people are, Airbnb or, or beach communities. This is a big controversy in beach communities because people own houses there that they don't live in full time. They're vacation homes. So when they're not there, they rent them out for money, which is arguably a commercial enterprise, And so the idea is, can we charge them more? And because in many cases they're using more money, more water, so yes, it can be done. I can tell you that it's controversial and it's tricky, and the county gets involved in those particular questions. But theoretically, yes, it can be done. But get good advice in doing it to make sure that it's done in a legally defensible way. That's what I'll say about that. Yeah.
And another question. We have a policy that attaches the water fees to the meter. The example is a customer moves and leaves a balance on their account, and we collect from the new owner if it is our policy to do so.
Okay, this is what since this seems to be this particular group, this is going to be an issue, and I'll just elaborate a little bit more. This is what we came back from the break and I made this comment because this is related to, can we file a lien for somebody else's unpaid charges? The question specifically is, I'm going to paraphrase, but my understanding of the question is that they want to tie the debt to the meter. So if the meter shows that this house has incurred a certain amount of debt, then they want to be able to collect from whoever lives there. And that was kind of what I was saying when I came back. Because if it's a water service, it's considered to be a contractual service between the account holder, whoever applied for the account, and the provider. All right, it's a contract that's personal between the two of you. It does not attach to the property, and you can't hold a subsequent property owner liable for the fees that the prior person didn't pay. All right, so as I understand the question, I'm going to say no, you can't do it that way, because that's effectively what you're doing, is you're attaching it to the property as opposed to the person who should have paid the bill. All right, there are other ways to collect. This is why your rules and regulations for water service, again, I don't want to get too far down this rabbit hole. This is very specific to very specific people. But if your rules and regulations should allow for sort of a increased authority to enforce your own ordinances. But late payments, the primary and most powerful way that is authorized by law to enforce delinquent accounts is shutting the water off. It isn't happy, it isn't popular, but boy, is that leverage.
Okay, so that's the primary objective. Other types of districts don't have that option. You don't have the option of shutting down the sewer. I mean, and there are good legal and sanitary reasons why one would not do that. But you do have leverage if you're a water provider to shut it off, but your regulations have to be clear on how that's gonna work, okay? Question?
We shut the water off. Still doesn't get paid. Place is sold. You have to turn the water on.
Yes. The question is, okay, theoretically, somebody doesn't pay their bill, you shut the water off, and then they sell the house and somebody else buys the house. Do you have to turn the water back on? Yes, you do. You can't leave it off indefinitely and just make the old, it's a way to extort the new owner into paying. This is exactly what I'm saying, is presumably if the new owner wants water service, they're going to apply in their own name and they're going to open an account, and it's no longer Mr. Smith, it's now Mr. Jones who's responsible for paying this. And then as long as Mr. Jones, the new owner, the account holder, is paying on time, then the water gets turned on as you would for any new customer. What you're stuck with, though, is an unpaid water bill, which is why filing a lien, very likely not going to work. Small claims court is an option, probably not worth it. What you're going to end up doing is writing off a lot of bad debt, okay? This is why in catching it early and enforcing it in the way that you can legally, which is we're going to shut your water off if you don't bring your account current. And there is also a way, if the reason why their account isn't current is because there are people who are in financial hardship. It happens, okay? There are ways to set up programs to help with that. But the way to handle that is kind of in a proactive way to try to avoid getting into a big set of arrears. But there may be times when you just have to kiss off the money because you're not going to be able to collect it. Yeah.
This is really kind of a rabbit hole.
Okay, then I might just have you talk to me at the break on it because we got a lot of ground to cover here. Okay. Yes.
So now this doesn't the fire district, or someone goes contrary to an ordinance, deliberately is contrary to an ordinance, and then that causes some kind of damage, a fire that we have to put out is contrary to the ordinance, because you can't do that, and they do it. And we can charge a fee for putting out that fire, dealing with that when they shouldn't have been doing it.
Okay, enforcing an ordinance is different. Your ordinance, if it's well crafted, will say what the law is, what a violation of the law looks like, and if you violate it, then there is a penalty. Okay, so it's going to be that this is what I'm talking about. Like in rules and regulations for water service, for example, the regulations are going to say if you don't pay your water on time, then we're going to do these things to you, including shut the water off. Okay. So what you're giving is another example of how you handle this proactively. If you have the ability to adopt an ordinance, then you have the ordinance, everybody knows what the rules of the game are, and then you enforce the ordinance, but it's going to fall to you to stay on top of that and not just let certain people slide and other people not, or let the water remain unpaid for 6 months, so you end up with a huge amount of unpaid water. So that's where you have to sort of be proactive in managing that process. And I feel like you really want to clarify something for us. So we'll go ahead, Kim, if you want to.
Well, no, it's not.
Are you sure? Okay, if you can clarify for water providers something that you found helpful, that'd be good. What do you think?
I was just going to ask if the multiple listing service purchase and sale agreement has any contents in it that obligate title companies to collect for unpaid utility bills at closing.
Well, and that's an interesting, again, it's a rabbit hole, and the evaluation just say you spent too much time on water lien. Yes, and again, solving these problems per client is what I do, what I get paid for, and that's one of the advice I would make is it is not uncommon when the property is going to change hands, like it's being listed for sale. It is not uncommon at all for the real estate agent to call and say, whoever provides the utilities and say, what's the status of this account? Or you notify them that this account is in arrears. They will sometimes pay that off in the interest of just making sure title is clear and there's nothing lingering out there. So there are ways to solve the problem, but you get the idea. So for anybody who has water provider problems specifically, see me at the break and we can talk about that. Because there's a bunch of people in here who are not water providers who are like, what? Okay. All right, so fees for service. So that's what that's about. Grants. A lot of government entities are funded by grants. It's common. Federal grants, state grants, revolving loans is another form of financing. So if you receive grants, great. If you, some soil and water conservation districts are, George talked about how they're kind of unique creatures. They are. I have several who are clients and you guys do interesting things. One of the things you guys can do is give money away. Most districts can't do that, but soil and water conservation districts can. So grants are a common source of income for government entities. Investments, so you can earn a return on your public investments. There's limitations on that, but the local government investment pool, some of you might be familiar with that. They kind of aggregate investments and get returns for you on that. Conventional loans and financing are an option. There is a statute that talks about some limitations on that, but for the most part, the local governments can borrow money or finance things the way anybody else would with some kind of collateral, usually full faith and credit, et cetera. Okay, system development charges is another form of financing, which isn't available to everybody, but if you're one of these kinds of providers, water, wastewater, parks, transportation, and drainage, system development charges are a specifically authorized form of financing, and as you'll see it abbreviated SDC. What that means is that the purpose behind an SDC is to require new development as development increases, and we add new houses and new housing developments and new commercial properties, that they have to help pay for whatever improvements to the infrastructure are necessary because they moved here. All right, so because you're expanding the number of connections, say for water or sanitary, one of these other ones, you have to service a bigger population of buildings. The idea is that those new ones have to pay part of the cost because you're going to have to either improve your plant or expand your plant because it has to get bigger or more efficient or, you know, newer in order to serve the new population. So the idea is that most SDCs are collected at the time of somebody acquires a building permit. So they go to the city or the county, depending on who the jurisdiction is, and acquire a building permit. And with that, they pay a certain amount of money. And included in that money could be an amount of SDC that is going back to whoever is assessing it. Okay, that's usually how that works. So if you're expecting a lot of development, anybody here know for sure that you have an SDC in place? You guys do, yeah. It's wonderful source of income for if you are experiencing a lot of development or expect to have this in place. But there's a few hoops that have to be jumped through ahead of time in order to make it valid and legal. It has to be based on a current capital improvement plan. The idea being that you have to know what you intend to pay for with this money. Okay, so you should at least, if you intend to expand your plant or replace it or do some kind of capital expenditures, that needs to be in a capital improvement plan that is adopted by the board so that you can base your fee on that. From there, then you develop a methodology, which is a way of figuring out, you know, there are engineers who just do this kind of work and it's very wonky and out of my pay grade. But what they do is look at, you know, how much growth do you expect and how many improvements do you need to make and what are those going to cost? And then they break it down on how much the SDC amount should be that's assessed for every new property. Okay. Okay, so that has to all happen first. And then the board adopts it by either resolution or ordinance, that's fine. You have, when the income that comes in has to be accounted for separately. So you have to have an account, not a separate bank account, but in your budget, you have to account for what is SDC income because it can only be spent on capacity increasing capital improvements as your capital improvement plan provides. Okay, so you can only spend it on expansions to the plant or new plant or whatever it is you're going to be doing. One of the one little caveat that I'll throw in here is that this is not some, it's not uncommon. I have clients who are kind of like, oh, yay, new fee. Let's let the board has now approved assess and development charge. That's not going to fly. And the reason why it's not going to fly, for one, because the law says it won't. But the SDCs tend to come under challenge by one particular group who is watching the costs of development. Any guesses on who that is?
Oregon Home Builders.
Or Oregon Home Builders, the Home Builders Association, very good. If you were to go, and I've done this, is look at whatever case law there is in Oregon that relates to SDCs, almost all of them are Home Builders Association versus whatever government entity they're challenging, okay? And the primary thing that they're looking for is, one, is it reasonable, but also did you follow all the requirements under the law? And is the amount of money you're charging fair and justified? Okay, sometimes I will have clients who will share with me, I'll ask for, give me your rates ordinance or whatever. And I'll be looking at all the charges and it'll say, it usually is called a hookup fee or a connection fee. And that's fine, you can do that, but the intention behind those, remember, they had to be reasonable. So your connection fee and your hookup fee are going to be based on what does it cost you to hook up a new customer, right? You're going to need a certain amount of staff time, you're going to need, whatever equipment you need to go connect them, et cetera. And then maybe a little extra for a little, to put into your reserves. I mean, that's a reasonable business-based calculation. If you have, however, a hookup fee or a connection fee that's in the tens of thousands of dollars or even multi-thousands of dollars, chances are pretty good it doesn't cost you that much to go connect somebody new to the system. It might, but probably not. And what you may have then is an improperly adopted SDC, because that's your intention. The intention is, well, we're going to charge new connections a whole big bunch of money so that we can put it in the bank and pay for improvements. That is an SDC that may be improperly adopted, and it sets you up for challenge. If you're charging somebody that and they themselves or the Home Builders Association on their behalf comes back and says, explain to me how you can justify a $10,000 connection fee. And then you're kind of in spot, like, well, we kind of can't. Then you're potentially, it makes it vulnerable to challenge. And the most common area of challenge, by the way, is the methodology. You got a capital improvement plan. Okay, we're not going to argue with you about that. You should know better than anybody what you need. However, have you calculated accurately how much needs to be charged for these kinds of improvements? Yes.
And the methodology can include prior improvements.
Yes, and
City Street.
exactly, yes. There's way more science to this than I'm getting into here, but there's an improvement fee and a reimbursement fee, and it's complicated. Yeah.
I just want to make the comment that when Sunrise made a major change to their SDC methodology, we actually contacted HPH to kind of come to our organization.
Oh, there you go.
In advance of putting that in front of the board. So when we did that, we had essentially negated any reason for them to protest.
Look at you being all cooperative and forward thinking. Good for you. I like that. Yeah, question.
If the fire district is looking to extend the city water and sewer to serve a fire station with a hydrant, can the district participate in an SDC or AFD to recover costs above and beyond grant funding?
Wow, boy, that's a hypothetical for the law school textbooks. I think that it sounds a bit like the question is, it almost sounds like, are they saying, can a fire district adopt an SDC? Is that what the gist of what they're saying? Yeah, the answer to that is no. Fire districts are not listed in the ones who are authorized to adopt an SDC. Doesn't mean they can't support the effort. Doesn't mean they can't be like, y'all go, we need your help. Consider an SDC, nothing wrong with that, but legally speaking, they can't adopt one on their own. Yeah.
Just say like our fire district tries to cooperate like with our city when it comes to those issues. And then as we say, hey, can you help us out with this by doing this thing? And so we get that cooperation, but we can't actually do anything. We have to ask them to do this.
Very good point. And to the degree to which you are all cooperating with each other, I love to see that because in many respects, you're all kind of in the same boat. And if you can work cooperatively on that, I think that's awesome. But very, very good illustration. Yeah. Okay. All right. There's also a form of financing assessments for local improvements. LIDs, you'll see that sometimes, local improvement district example. And in theory, what this is, and not in theory, in reality, it's a way to, let's say you need to expand some part of your, you need to put in a new water main or a new sewer main or, something that's only going to be benefiting. It isn't going to benefit everybody. It's going to benefit a discrete number of properties. Okay. This, we need to dig up the street and replace this because it was built in 1905 and we need to replace it. There are ways, and there's a lot of hoops that have to be jumped through, but ways to assess the cost of that to the individual property owners who are benefited by it. And then that can become a lien if they don't pay it. In most cases it will, because you're going to enable them to pay it in installments. But that's a way to, if you just have a local improvement as opposed to, improving your entire plant, then an assessment process might work. Okay, these other two are forms of borrowing. This government issued bonds. The most common one you'll see is general obligation bonds, or GO bonds. You see that illustrated. Those are paid back. Those are a form, government sells the bonds. So this is when you, if you're into investing and you want to invest a certain amount of your money in government bonds, they tend to be considered very safe because they're almost always paid back. But they're also not particularly high yield. You know, they're not real risky, but they kind of plod along like a workhorse and pay you back a little bit. That's local general obligation bonds. So the board can decide if they want to go borrow a bunch of money in this way, issue bonds. If you have the authority to go out for a bond, it'll say it in your principal act. So you need to go look and see if you have bonding authority. And if you do, it must be used for capital construction. So a GO bond is a lot of money that you're borrowing because you're going to build something. Usually it's some kind of building, but it could be, you know, you need to build a new water treatment plant or something like that. It is paid back with property taxes. So it has to go to the voters, must be money measure, must be approved by voters. It goes to the voters. Double majority will apply at those elections where double majority is required. All right, voters have to approve it. The nice thing about this, however, is that what you're collecting in property taxes is not subject to compression. Okay, so your other property taxes, local option levy, permanent tax rate, you may find yourself in compression. For a GO bond, if it's approved by voters, you collect whatever you collect. All right, the property tax, it'll say it in the measure how much is going to be assessed in additional property taxes, and you collect all of it, whether the area is in compression or not. And obviously the logic there is you want to be able to pay this bond back. Your investors want to be paid back. So that's why that happens. It's a handy form of borrowing. SDAO, by the way, offers some great help if you're interested in bonds. Talk to them because they have some programs they can refer you to. And then revenue bonds are another form of borrowing. It is not necessarily it is not a property tax measure. It's basically, it's a form of borrowing where it's paid back with any available revenue of the district. You'll see this with a lot of times for districts that are funded by fees. You know, they don't assess a property tax, but they have a certain amount of, you know, their income is based on fees and charges like water and sanitary districts. And revenue bonds can be authorized by the board. The board can adopt a resolution saying we are now going to authorize the issuance of revenue bonds, yada, yada. And it does not need to go to voters because it's not a property tax. However, it is subject to referendum. So if 5% or more of your customers or your constituents notify the board they want it to go to the voters, then it has to go to the voters, okay? So, and if it goes to the voters, the double majority analysis will apply to that, okay? All right. Anybody have a form of financing that I didn't touch on here? Once in a while, we get an interesting one. Are you getting your income from someplace other than the things we've talked about?
There's some state programs as well. State programs that are infrastructure bonds that pay back, but they're primarily a type of revenue.
Okay, all right.
And general obligation bonds can be paid back with revenue with property tax as a backstop. Is that true?
You know, the nuances of general obligation paying them back, I can't tell you. I can tell you that the idea is that they're supposed to be paid back with property taxes. But the property taxes could be, you hear the term full faith and credit, which is basically what you're doing is saying, we have the ability to assess taxes. We are pledging that as collateral. We will, if we don't pay it back, then you can come after our full faith and credit. That's the idea. So again, the nuances of that, I don't mind really, that's another.
GO bonds tend to have lower than revenue.
I'm sorry?
GO bonds tend to have a lower interest rate than revenue bonds because of the tax, being able to assess them rather than being subject to vagaries of the economy where revenue bonds might have.
Okay, good. Thank you. Question?
Are there timeframes that these bonds have to be paid back?
Yes. Yes. And usually, you know, they're usually like 20 to 30 years, 20-year repayment period, 30-year repayment period. It all depends on the, you know, you'll have to have bond counsel and you'll have people who will help you with all that, but they're paid back over a long stretch of time. Okay. I want to talk about local budget law very fast. This will be familiar to most of you who've been doing this for a while, so I'm not going to spend a lot of time on it. My understanding, and I know for a fact that the Oregon Department of Revenue does training on local budget law. My understanding is it's very good, and I believe it's free to those who attend. And there's also the final few slides of the materials are the slides you have here are resources that are available to you, and the Department of Revenue puts out a budget. They put out the kind of the long, complicated budget book, budget manual. Then there's a shorter, kind of simpler one, budget manual. Those are available for free online if you go to the Department of Revenue's website. And I would defer those detailed questions there. I find them helpful whenever I have to deal with local budget. But in just to review the process really quickly, the local budget law, anybody who is assessing a property tax is subject to these laws, and some other districts that are being financed in other ways may be subject to these laws. There are some exemptions in here. Health districts, for example, have their statutorily different budgeting process, so they're exempt. Soil and water conservation districts that don't assess a property tax are not subject to these laws. They might have to do something different. But for the most part, everybody in this room is going to probably have to follow the local budget law. And the procedure, you do it every year, so it should be pretty familiar to you. But the premise is that you create a budget committee, which consists of your board of directors, and then an equal number of citizens who, if you can find them, you do your best. In some communities, it's easy, others not so much. So in theory, you have a 5-member board, you'll have a 10-member budget committee. And then you have a budget officer who is usually the manager of the district, but doesn't have to be, could be anybody, but their job is to kind of shepherd the process along. They prepare the initial proposed budget, they craft the budget that will go to the budget committee. The budget committee will then have hearings and meetings and talk about it and massage it and do whatever it is that they do. And then once they're done, then they have a proposed budget. The budget committee is done as a budget committee. And then the budget goes to the entire board, and the board has more meetings and more hearings, et cetera, takes public input, yada, yada. And eventually they adopt a final budget. We cover all that in very quick fashion. And then June 30th is the deadline for filing the budget, okay, with the Department of Revenue. That's filed. And then from that, then if the governing body figures out how much tax do we need to assess under this budget in order to get the income that we need. And then that is certified to the county assessor by July 15th. And then, come fall, you can start collecting your tax revenue. And so, those of you who've been doing this for a while, it's very familiar, you know the pattern, okay? Everybody who is subject to the local budget law, and in some cases others, are also required to follow the municipal audit law, which means that you have to have some kind of reporting to the audits division about your budget. All right. And if you are a big enough district, and the standard is if you are expending 500,000 or more in a year, then you have to do the full-blown audit where you hire the municipal auditor, and they do get into the weeds in your expenditures and give you recommendations, et cetera. And then the audit is filed with the Secretary of State. There is an option that's called a review, which is a kind of an audit light that's available for smaller districts. If you're under that amount, you are required to report to the auditor, the state auditor, with your report. But I haven't seen one, but my understanding is it's pretty simple, pretty straightforward, but not as complicated as a full municipal audit. That was the very basics of public financing. As you can see, there is a lot of room for expansion of details that we won't get into today, but it is a complex area. But at least hopefully you have some basic understanding of how this works. Any lingering questions about the things we've talked about on that?
I just wanted to mention that if you want to get some further background on finances and stuff like this, you go to the League of Oregon Cities website. They dig deep into that thing too, about financing and changes and stuff like that.
And SDAO has some resources available to you as well. And your personal lawyer can probably guide you through the process if need be. But hopefully you'll at least have a better understanding of all the options that are out there. All right, so on a related note, the last section was really about how you get your money. And this next one is about how you spend your money. And this will take us up through the lunch break, okay? And we're talking about public contracting. This is another area of law that's very complicated, and there's a lot of nuance and niggliness to it. I have participated in an 8-hour public contracting seminar teaching it. We don't want to do that today. It's a boring topic to teach. And it is sometimes hard to get your head around all the details. However, I wanted to give you just an orientation. This is the kind of thing that all of you are going to be doing in some form or other. So I'm going to walk through the basics of the law with you. Included in that is the applicable laws. We'll talk about competitive bidding, the criteria for awarding it, the exemptions from bidding, the types of contracts that you will encounter, the solicitation document, and then the authority to award a contract. We'll touch on all of that. Preliminarily, anytime you are spending public money, there is a contractual component to it. So if you are buying something, paying someone, et cetera, then you should assume that there might be a public contracting analysis that might have to happen, okay? A couple of basic things. We have in Oregon what is called the Public Contracting Code, which is referring to this set of 279 A, B, and C, which are all subchapters of 279, okay? All your public contracting code is contained in there. They're divided up in subchapters by design. At 2005, the laws were changed substantially, and this came out of that. 279A, if you went and read it, is a bunch. It kind of applies to public contracts generally. It'll say it'll have definitions in there and what needs to be in your RFP and blah 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 blah. 279B deals with procurements, which is where most of you are going to spend your dollars, right? You're going to buy stuff. You're going to buy desks and paper and computers and whatever. That's a procurement under the law. And then 279C, by design, they pulled all of the construction related stuff and put it in one subchapter, because what was discovered is that the constituency, the stakeholders who are out in the world agitating about public contracting care a lot about what happens with construction. All right, the trades are concerned about that. BOLI is concerned about that. There was a lot of angst around construction. But people don't get all that worked up about how you go about buying your pencils. Okay, it's just not the same. So what they did is kind of pull it out into its own subchapter. And anytime you're going to build something, then the law gets pretty complicated pretty quickly. Okay, but we're going to walk through each of those categories a little bit so you can get oriented on how to handle them. There also is something called the Oregon Attorney General's Model Public Contracting Rules, which are in Oregon Administrative Rules, Chapter 137. The reference is in the slides at the end. But anyway, what these are, every contracting agency, so if you're a public entity, you are a contracting agency under the law, okay, and you're subject to these laws. And every contracting agency is required by law to have public contracting rules. All right, those are called your local public contracting rules. Those rules govern how you are going to do your contracting, okay? There are, the model rules exist that apply to the state of Oregon and its purchasing. Okay, there are administrative rules that say this is how the state of Oregon is going to do our purchasing. They're called the model rules because every public entity is required to have rules, and if you did not have rules that you've adopted, these will apply to you by default, so that nobody is without rules. So if you don't want these to apply to you by default, then you should affirmatively adopt your own, and I'm going to tell you why it's a good idea to do that. So that when you hear the model rules, that's what we're talking about. And then you have your local contracting rules, which are your internal rules for how you're going to award your contracts and competitively bid them, et cetera. They have to comply with the statutes. However, you have a certain amount of room to tweak them so that they work better for you. The model public contracting rules, as I've said, are for the state. They tend to be way more, in some cases, way more complicated than many of you need. I will go through and tell you the areas that I think you either must or should make some changes. When I prepare resolutions, public contracting rules for my clients, it will usually say something like, we adopt the Oregon Model Public Contracting Rules with the exception of the following. And then we sort of pull out certain things that I've worked with them on how to make it work better for you. And you have that latitude in some cases. Okay, the definition of public contract. I know I was sitting in the back and I couldn't read this, but I apologize again because it's so small. Public contract, the definition is a sale or other disposal or a purchase, lease, rental, or other acquisition by a contracting agency of personal property, which is stuff, services, which are, just kind of routine services that you need, personal services, which we'll talk about, which are your advisor class, public improvements, which is construction, public works, which is construction subject to prevailing wage, and then other kinds of repair or maintenance. So whatever it is that you are buying or leasing or selling or getting rid of, disposal. Those are all considered public contracts under the law. Okay, so these laws are going to apply if it meets that definition. There's some things that are just not public contracts because the law says they're not. That includes grants, the giving and receiving of grants. That grant making process is not subject to these laws, and you don't have to get the low bidder, et cetera. Once the grant is in your little bank account, however, you will be subject to these laws. So just because it's grant funded doesn't mean you get to avoid all of the requirements of the public. If you are buying or selling real estate, that is specifically exempt. So if you want to go buy a property or sell a property, there's no low bid requirement in any of that. You buy or sell it, get the best deal you can as any private person would. Intergovernmental agreements, IGAs, those are outside of the public contracting. So other governments, you and other governments can agree to buy things from each other or sell things to each other or sell things, do whatever you're going to do under the IGA, not a public contract. And then if there's no public funds that are being used, like whatever it is you're doing is entirely funded with a donation, donated labor, donated money, if there are no district funds being used, then that is outside of the public contract definition, okay? The local contract review board, the local contract review board, sometimes this term trips people up a bit, it shouldn't. The local contract review board, if you went through the statutes, there are certain things that the local contract review board is responsible for. Adopting exemptions, which we'll talk about, is one of them. Conducting hearings, when there are hearings required, then they conduct the hearings. Limited role of the local contract review board. Your local contract review board is your board of directors, unless you have said otherwise. Okay, by default, the board of directors is the local contract review board. You don't have to have separate meetings. You don't have to, have separate minutes. The local contract review board is the board of directors acting with its local contract review board hat on. All right, and that's all you have to be concerned about. So the board of directors is the local contract review board. Yes.
So what is the formally proper way within a meeting to activate the contract?
To activate it? In my opinion, you kind of don't really need to. If you're going to do everything by the book and make it clear that we are acting as the local contract review board, I would just have that reflected in the minutes. The board is acting as the local contract review board, the board adopted an exemption from competitive bidding, and it should just say that in there. That's really all you have to do. Unless you want to do like a drum roll or a, kind of fanfare, woo, you really don't have to do anything special. It just should be denoted in the minutes. I mean, the fact of the matter is, because the board has this authority, you will be carrying out the authority whatever you're being called. It doesn't really matter what you're calling. That the issue is that you're complying with the law and how you're carrying it out. So I wouldn't get overly worked up, but if you want to do completely cleanly, just say it, mention in the minutes. That's how we do it. Okay, competitive bidding. The default for public contracts is always the lowest low bid. Everybody thinks that, everybody believes that, the public believes that. When the changes were made in 2005, that became less of an assumption than it had been historically. I'm going to tell you where and why. Unless there's an exemption from competitive bidding, and there's lots of ways to exempt something from competitive bidding, assume that there will be a competitive bidding component, all right? Their statutes exempt certain things from competitive bidding. We won't go through all of them, but they, sole source fixed price, like it's available from one source. Usually it's a price established by federal law. Everybody pays the same thing and it's only available in one place. That is exempted. Investments are exempted from competitive bidding. Certain contracts with if you, again, that gets really wonky. The Department of Administrative Services is supposed to keep a list of all of the qualified agencies that provide employment to the disabled. Those entities, they're nonprofits, they provide employment opportunities to people who are with intellectual or physical disabilities, and they get paid to make something, whatever that thing is. And there's a list that the Department of Administrative Services at the state keeps. And if local governments need whatever is being made by those groups, and it's within your budget and meets your specifications, you must buy it from them. Many districts, in my experience, don't know that, but it might be interesting to just go, the list is online, you go check the list and see what is being manufactured by these groups. So that's, anyway, if you find it there and you buy it from them, you don't have to put it out to competitive bids. Here's what I'm colloquially calling a piggyback contract, which under the law is called a cooperative procurement. And this is where somebody sometime did put it out to bids, jump through all the hoops to do a competitive bidding process. But the process allows other governments to kind of hop on and take advantage of that. So you see group purchasing, federal or state, ORPN, or what is now called Oregon Buys or something like that. It used to be ORPN. That's that example where the state has already put it out to bid. You know, we agree that we're going to sell you this thing for this amount of money. Local governments can hop on to that, joint purchasing. There are some requirements that have to happen, but if you are part of that, you don't have to put it out to bid again. You're exempt from that process. The local contract review board can do what's called a special procurement, which is, that's the term of art for an exemption from competitive bidding. Under certain circumstances, and this is something that does fall to the local contract review board to do under the statute, is they have to adopt written findings to justify why we're going to exempt this from competitive bidding. They have to propose an alternative approach that somehow promotes competition and is in the best interest of the district. And there's a bunch of process associated with that. And then they adopt a resolution that exempts this particular contract or this class of contract from competitive bidding. So exempting things from competitive bidding is within the jurisdiction of the LCRB if they do that, but it's it is process heavy and you want to be careful with it. So if you're going to do that, get some legal guidance on how to do it correctly. Local rules can exempt certain things from competitive bidding under certain circumstances. One good example is your emergency rule. This is something that should be specific to your local rules. And the statutes specifically punt this to local governments to figure out how you want to handle this. What your local rules should do is define emergency. This is one that I proposed, creates a substantial risk of loss or damage and was unexpected. Yeah. So you say, what do we consider to be an emergency? And then your rules are going to establish a process for how you're going to award that. You don't have to go after competitive bidding if the emergency exists and we follow our policy. And our policy is usually, it should name at least one, and sometimes I prefer to see at least two people who are authorized to act in an emergency. So they have to document the emergency for the file, either before or after. And then they can go out and just find whoever it is that they can, do as much competition as you can under the circumstances. And then you don't have to do the whole competitive bidding thing. Okay. But that's an area to give yourself a lot of latitude to act in an emergency. The authority to award a contract. Remember, we talked about the fact that only the board of directors can bind the district legally. Okay, so the board is required to approve all contracts, all written contracts. However, they have the ability to delegate some of that authority formally to somebody else, usually the manager or the fire chief or whoever's in charge of operational, decision making. But they have to do it by rule. So your local rule should say, the board must approve all contracts except. And then it's going to specifically say how much of that authority is being delegated elsewhere. And it's usually a dollar amount, like anything, over $10,000 must be approved by the board. And if it's smaller than that, then the district manager has that authority or words to that effect.
Those dollar limits, any of those dollar limits strained by 279 language?
We're going to get to that.
Okay.
Yeah. That prior one was just delegation. That doesn't have anything to do with it. Yeah, yeah, that doesn't, no, it doesn't. Okay. Okay. When one is going to award a contract, whatever form of bidding that will apply, and I'll tell you the different approaches you can use. There are sometimes when just a direct award is allowed. And I'm going to explain to you when that is. Direct award means no bidding is required. We are not required to put this out to bid. We're going to award it directly. If that's the standard, if that's what you're going to do, then the standard under the law is you award it in any manner deemed practical and convenient. You have a lot of discretion if you've met the criteria to just award it in the way that you deem most appropriate. There is also an informal bidding process that may apply, which is where you don't have to advertise it in the newspaper or have a big solicitation document. What you're going to do is try to find, you have written specs and you try to find at least three qualified people to bid on it. And then you pick the one that best serves the interests of the contracting agency, taking into account price as well as a bunch of other stuff. So notice this does not say you have to award it to the lowest bidder. What it says is you consider price, but you consider a bunch of other stuff. And then you award it to the one that seems to be giving you the best value. All right, so this is an example where the laws were loosened quite a bit in procurements to allow you to get the thing you need and not necessarily the thing that's the cheapest. All right, so there is that latitude available for informal bidding. And then the formal bidding, anytime you're getting into contracts of any size, we're going to talk about those. The law will require you to advertise them in the newspaper and to have a solicitation document, RFP, or an invitation to bid, et cetera. Those are the formal ones, and those standards are higher. All right. In that case, you have to award the contract to the lowest responsible bidder. And those are two things. Responsive means that they have given everything that you've asked from them. They've turned it in on time. Certain, you asked for 5 copies, they've given you 5 copies. They've given you proof of licensing. They've given you, answered all your questions in your RFP, and they've been responsive. Okay, that's responsiveness. Responsible means that they've shown that they can do this job. They have the manpower, the time, the experience, the equipment, whatever it is that you need for the job. And so both of those criteria have to be met. And if they don't meet one or both of those, then they are disqualified. So the formal bidding process is a lot more at stake there. All right, now, and one of those methods is going to apply, but it really is going to depend on whatever type of contract you have. So the first step, the first analysis is always, we need to buy this thing or spend this money. You have to figure out what kind of a contract are you looking at. And how you award it will depend on, it'll fall into one of these 4 buckets, all right? It's going to be personal services, procurements, public improvements, or surplus property. Personal services. These are professional services. These are the ones you're hiring your advisor team, right? It's going to be your lawyer and your accountant and maybe your auditor and your architect and your engineer. The kind of people you are hiring, not because they're the cheapest, but because they have the knowledge you're looking for. They know your industry. They know you trust them. That's your advisor team. Those are professional services contracts. And we'll talk about the specifics of how to award those. It's not personal services, it's procurement. So we just need to go buy some stuff, all right? And that includes things that are not personal services, but might be services like janitorial services or basic bookkeeping, or the kinds of things you don't necessarily need a white collar professional to do, but they're services. Those are considered procurements. And then public improvements is how the construction contract is defined. So it's a public improvement. Or it's surplus property. Remember that disposing, who owns public property? The public. It belongs to them, all right? They own it. So that's considered a public contract when you want to dispose of surplus property. So each of these are different. It's going to fall into one of these 4 buckets. And if it doesn't, start over because you missed something, all right? One of those 4 buckets will apply. And then how you award the contract depends on how you're defining or what category that falls in. The first thing you want to do, and give yourself this much latitude if you can, your local rules, local governments can adopt local rules for awarding personal services contracts however you want to. You have that much latitude. The statutes say that. They say local governments by their rules can decide how to award public professional services contracts. So the first step is always in your rules. And occasionally I've highlighted in yellow all the ways that's a little tip for me, like look at this because you might want to adopt your own rule. The first thing you do is define personal services. What does that mean for you guys? And there's the standard ones. There's the lawyers and the engineers and the architects and the ones I rattled off before. But for your type of district, that might include some others that are unique for you. You probably can't see this from where you are, but I've included in this definition, computer programmers, artists, designers, performers, consultants, outreach coordinators, workshop facilitators. So depending on the type of work that you do, like soil and water conservation districts, for example, are doing a lot of community training. Okay, they might not do that with their staff. They might hire people to do that. They can do that and call them professional services because they're looking for a certain set of skills, a certain knowledge base. Similarly, library districts, for example, do programming. They have the musicians, or they have puppeteers, or they have somebody that they're contracting with, and you don't want them to be the low bid, right? You want people who actually are going to be good. You can tailor this definition within reason to include personal services that make sense for the work that you do, okay? So give yourself a little bit of latitude and think about what that definition is going to mean for you. And once you have that definition, then your rules can propose that you can award them directly if you choose, which means you do no competitive bidding. You just hire the ones you like. You know, we like that lawyer. You know, he's done good work for us before. Let's hire him. That's okay if your rules allow for that. Or you can always put it out for competitive bidding, request for proposals if you choose, and your rules can allow you to do that too. So have your rules define how you're going to award your contracts. Now this one, there's a little bit of a caveat in there. Architects, engineers, surveyors, or photogrammetrists, who are the professionals who are usually associated with construction. There's a little bit of extra process associated with those. If it's $100,000 or more, it pretty much must be put out for competitive bidding. And you have to apply the qualification-based selection analysis, which you have to choose them based on qualifications. And if they're qualified, then you negotiate price. Okay, what they want is to make sure you're getting the best quality in your contracting process. Okay. Otherwise, then you just award them however your rules say you're going to award them. So professional services, pretty easy. Procurements, which is anytime you want to go buy stuff, are in their own bucket. And in there, that's where those statutory dollar amounts come into play. This is, if it's under $10,000, it's called a small procurement, which means it is a small contract. Just go buy it. You don't have to worry about competition if you don't want to. Just buy whatever you need. Get the best deal you can. Then the second category in there is an intermediate procurement. And as we talked about, if it's between $10,000 and $150,000, which is many of you will not spend more than that ever, then you can do the informal process if you choose, which means you have the written specs and you give them out to at least 3 people you know to be qualified, and they give you their bids, and you make them choose the one you like the best. And remember, it doesn't have to be the lowest, the cheapest. It can be. You should consider that. It doesn't have to be. Intermediate procurement. And then we have 2 B's here. If it's more than 150,000, it's considered a formal procurement. That's where the statutes will require you to advertise it in the newspaper, and there's a bunch of stuff you have to do, a formal bid document. All right, the third category is public improvement, which is construction. If you have a limited amount of dollars to spend to pay your lawyer, spend it if you're planning construction, because it gets complicated very quickly. It's a highly litigated area. Public improvements are any construction performed by or for a public agency. So if they're doing it on your behalf with your money, whether it's on your property or not, it's considered a public improvement. If it's 50,000 or more, it's called a public work because it's subject to prevailing wage. And if you're not familiar with prevailing wage, it's like a minimum wage, if you will, for people who work in the construction trades. BOLI, Bureau of Labor and Industry, sets those. They're regional and they're broken down very specifically. You can go look at them online. And it would say, you know, master electrician, so much per hour. Journeyman electrician, so much per hour. Apprentice electrician, so much per hour. And they're broken up very specifically like that. If it's 50,000 or more, it is subject to the payment of prevailing wages. It's up to the contractor, whoever you're hiring to do the work, to pay the prevailing wages to their people. That's their job. Your job as the owner, and we'll cover, I'm going to summarize all this in the end. And so if you're feeling a little lost, don't be yet. The district is the owner for purposes of these contracting laws. And as the owner, your obligations for prevailing wage are to include in your advertisement that's the prevailing wage job, include in your solicitation document, your invitation to bid, that it's a prevailing wage job. And then you have to, the contract has to say it's a prevailing wage job. And then you have to, someone has to, on your end, has to check certified payroll and make sure that prevailing wage is being paid, okay? Prevailing wage jobs tend to pay way better than in the private sector, which is why there's a lot of competition for them. And it tends to, there's a lot of litigation if you do it wrong, okay? Okay, so in the public improvement context, again, small procurement under $10,000, just award it. You know, you're going to build a tool shed or a birdhouse or something, and there's a small procurement. There's also an intermediate procurement category, which is the informal bids, but the cap on that is $100,000. All right. And then for the large ones, if it's over 100,000, you have to do the formal bidding process, which is the advertising it, solicitation document, and then also there will be forms of security that you're going to have to obtain. Question?
Yeah. Are repairs also handled this way? What if you have a contract with an agency, but the repair is over?
Good question. The question is, what about repairs? The minor repairs and maintenance, and then again, you have some latitude in what's considered minor. Let me give you an example. You have a big windstorm and it blows off a section of your roof, okay? If it's not the entire roof, it's probably a good argument that it just needs to be repaired. It needs to be patched or partially replaced. That is considered a procurement. It's not a public improvement. And you follow the rules for procurement, which means depending on how much you think it's going to cost, if it's in that intermediate category, which it probably will be, it probably won't be over 150,000 unless you have a really big roof. Then you can do what you would do for an intermediate procurement for anything else is you get 3 people to give you a bid on it and you go with the one that gives you the best deal. Okay. However, if in fact most of the roof has blown off and you really are going to have to replace the entire roof, that will put you into public improvement category, and then you have to follow all the formalities for construction. So again, it'll depend on how much you think it's going to cost you, but because it's likely to cost you more than $100,000 in that context, you're going to have to do it as a formal bidding process, unless it's an emergency. So it really depends on the facts. But I hope that answers the question. Yeah.
Another question. Ask, if you have a public improvement project that may cost $60,000, but $20,000 in materials is donated, is the remaining amount of $40,000 available?
It would not be, because when you determine that when you calculate how much it's going to cost you, you want to look at what it's going to cost the district, and you can deduct from that donated anything. If somebody's going to donate a certain amount of materials or labor or something, then you deduct that from the cost. And if you're under that 50,000 threshold, then it would not be a prevailing wage job. Okay. All right. I know this is dry and boring and you want lunch. I know that, but we're almost done. Okay, I'm going to wrap it all up for you in a pretty little package that you can take home with you. And you'll be like, oh, okay, I'm so glad I heard all that. Okay, prevailing wage. Okay, we talked about prevailing wage. There is also, and you should be aware of this, if it's 100,000 or more, the law cares very much that the district's interests are protected. And there are 3 ways that you're required to do this as the owner. There are 3 different forms of what are called security. The first is a bid bond. When you put it out to bid, you're going to require for the big projects that whoever bids on it also has to submit a bid bond. And a bid bond works, it's 10% of the total bid amount. And it works like, it's a letter of credit. And it basically, it works like earnest money, but they're essentially saying we're submitting this in good faith. If you give us this job, we're ready to do the job. Okay. And if they sign the contract and they get the job, you give them their bid bond back. All right. You award them the job and they're suddenly unavailable, we went bankrupt or we died or we can't do this, we got busy. Then you get to keep that bid bond amount as kind of like a penalty for your time and trouble that they didn't follow through. Okay. So that's a bid bond. Performance bonds and payment bonds are 2 separate bonds that are obtained at the time that you enter into the contract. Okay, you don't move forward until you get them. Performance bond is essentially a guarantee that the work is going to get done as agreed. Okay, they're going to perform, and they're going to do it for the amount of money that they've agreed to. All right, so if they do the job and they do it fine, then fine. Nothing happens with the performance bond. If, however, you get into the process and they either walk off the job or become unavailable, or the job is going so poorly that for goodness sake, let's yank them off the job, then you have the ability to make a claim against the performance bond, where the performance bond company then will find somebody to come in, finish the job, and you don't pay any more than what you otherwise would. Okay, so it's a way to make sure the job gets done as agreed. Payment bonds are another form where the contractor is required to pay everybody that does the work. All right, they pay their people, they pay their subcontractors, they pay their vendors, their suppliers. It's their job to pay those people. If, however, they didn't, you as the owner can be responsible for, or are responsible for, paying all those people because you benefited from the work they did or the thing they gave you. And you don't want that. So the payment bond ensures that everybody gets paid as agreed. So if somebody makes a claim, hey, I didn't get paid, the payment bond is there to ensure that they get paid as they should have been. All right. So they'll just, again, for large construction contracts, anything over 100,000, those are almost always required. Okay. All right. The other bucket that you will find yourself in for public contracting is surplus property. If you own a property, it belongs to the public, as we've talked about, and then the prior days and the before times, before 2005, districts were required, at least to advise them this, that you had to basically get the best return you could. And that usually meant some kind of auction, right? You had to sell things. You would see auctions of publicly owned property. People would come and bid on them. And you don't have to do it that way. You can do it that way now if you want to, but you don't have to. Because what the law says you need to do, and this is another one that's punted to local government. There's no specific law that applies to you. So you have to adopt your own law. And you're going to adopt in your rules, how are you guys going to dispose of surplus property? We have this stuff, we don't need it anymore. We have some obligation to handle it in a responsible way. So you're going to adopt your rule that says, first you're going to define surplus property. I've given a sample definition there, but it's essentially stuff that you don't need it anymore. And you're going to give yourself some rules that say, if, it is thought of the district manager or the board to decide, we don't need this anymore, then you can give yourself some options. If it has no value, then you can throw it away. If it has some value, but you could donate it, like used computers, donate them to the school or something like that, give yourself that option. You can sell it on eBay. There's all kinds of options available, but make sure your rules just give you the authority to do it. And then depending on what it is, then you're perfectly fine to follow your own rules. Okay. This, like professional services, is a way to give you as much latitude as possible. Okay, you cannot see this. I know you cannot see this. I can barely see this. And it's on your slides. My understanding is it's also very hard to see because it's so small. And by the way, SDAO has agreed to email this to you if you want it. All right, so it can be enlarged. But what it would say, if you could read it, is it's a quick reference guide to public contracting, and it's everything we just talked about. So you got something got to buy. You're gonna primarily go buy something. So this is kind of just a flow chart on the steps you should follow. One, the first question is it a public contract? So there are some things that we talked about very early on that are just not within the definition. They're not public contracts. Anybody remember what any of those?
Like architects, engineers.
Nope. Back up, a few more slides.
Oh.
Not even in the definition of public contract. Real estate, that was an example. Intergovernmental agreements. Anything that doesn't require any public funds. The grant making process. Those are not public contracts. And if it's one of those, then you don't follow any of this. Then there might be other requirements, but not here. All right. So the next question is, if it's a public contract, why? Yes, it is. I believe it is. Then you figure out what kind of contract is it? It's going to fall into one of these buckets. I didn't put surplus property on here because that's kind of its own thing. But if you're going to buy something, it's going to be personal services, which is the professional services we talked about. It's going to be a procurement, which is going to buy stuff, or it's going to be building something, okay, public improvement. So it'll fall into one of these buckets. And depending on which bucket it falls in, personal services, follow your rules. If you have rules, then you just follow your rules. The only caveat, as we mentioned, is architects, engineers, and surveyors, that if it's a big enough contract, you're going to have to use that QBS process that we talked about, okay? But otherwise, anybody else, your lawyer, your accountant, your engineer, well, actually engineers are included in there, but then you just award it however your rules say you're going to award it. And usually you should have something in there like, we will have some sort of standards for what kind of qualifications you're looking for, but follow your rules. Procurements, which is where most of you will spend, depend on the dollar amount. We have those $3 amounts, and the dollar amount we define the process of what you're going to follow. And then public improvements, which is construction. Again, there's those $3 amounts. You figure out where those are. And then if the formal ones, if it's bigger than $50,000, then there's a bunch of statutory stuff you're going to have to be concerned about. Prevailing wage being one. And if it's over 100,000, then there's more requirements. So again, if you have a limited amount of legal dollars to spend, I'd save them for construction. Or if you're going to go out, if you're going to go do a competitive bidding process for something, it's a big enough contract, you're going to put it out to competitive bids, whether it's construction or something else. Please, please, please spend your legal dollars at the time you prepare your invitation to bid or your request for proposals. If that's called your solicitation. If the solicitation document is done properly, you can forestall and prevent legal challenges of all kinds. Okay, very, very rarely when it's done well will contractors challenge it. Where the challenge is going to come in is where it's not clear, it's subject to interpretation, it's clearly does not follow the law, or there's something in there that is suggesting that you're not being fair. You're not putting in a level playing field. So it is not uncommon for me to have clients who, they're trying to do this on the cheap. I get it. Lawyers can be expensive, but they'll do the RFP or request for proposals, invitation to bid on their own, and then they'll put it out to bid. And then and then they end up, things hit the fan and they're getting all these challenges and people saying, I'm going to sue you because you did it wrong and you violated the law and yada, yada. And they'll call the lawyer at that point. And then when they do that with me, I'll say, can I see your solicitation document? Because that will help me. And they send it to me and I look at it and I'm like, oh, you guys. No. And they did their best and they could, but again, there's a lot to, especially for big contracts. There's a lot of stuff that should be in your invitation to bid. Spend your money there and save yourself the time and the trouble and the hassle and the money of having it be challenged after the fact. Okay, that's another of my little tips for you. Okay, so that's public contracting. Any lingering questions before we break for lunch? Yes.
As far as the money limits, as far as that, because there's a lot of flexibility in terms of how you think it's going to be, and then a couple of weeks later, it could suddenly blow up and suddenly it costs like another $20,000 and boom, you're over the limit. So you have to just roll it back and start over again, or?
Generally not. And it's a good question. Usually it comes up often, frankly. There are, if your contracting rules are well crafted, you have the ability in there to put in some wiggle room. Where to say that, a small procurement may exceed this dollar amount by, and it's the model rules give an example of this by, 25%, as long as the scope hasn't changed substantially, but just the amount has, then you can give yourself a little bit of room to navigate
Or
that.
you have to put that in your rules.
It should be in your rules. Yeah, because as you point out, you kind of, from the beginning, you're almost always working with an estimate. Like, we're gonna need to build something. We don't know for sure what it's gonna cost us. We think it's gonna be $5 million. And then it turns out to be, but those dollar amounts, you can build some wiggle room in there. But if you're way over the, if you thought it was gonna be under 10 and it's really 15, you don't want to be acute about trying to skate under that, especially if it involves prevailing wages. BOLI, who administers those laws, they watch these things and they will come after you if you are doing anything that suggests that you're trying to dodge the prevailing wage requirements. Question from the ether.
What governs the disposal of surplus real estate since not considered a public contract?
Good question. The question is, what governs the disposal of real estate? Anybody from what we've talked about want to volunteer an answer for that? You need to sell a piece of property. What do you do?
List it with an agent.
List it with an agent. Yeah, exactly. And we've talked about this in a couple different contexts. Real estate is not considered a public contract under the law. When we talked about boundary disputes, you're treated like any other private entity, and real estate is one of those things. You have some property you want to sell, you're going to sell it like anybody else would, meaning that you're going to get an agent maybe, or you're going to work with a lawyer, or somebody's going to sell it. Similarly, if you want to buy it, okay? Both those transactions, when we get to records and meetings, you also can do all that confidentially, which the argument is you get a better deal if you can negotiate privately. So that's real estate is treated separately it's not considered a public contract for all of these reasons. You just deal with it like anybody else would. There is a statute that applies. It doesn't really require much. 271, which talks about selling, disposing of publicly owned real estate. And it basically says the board has to officially agree to sell it. That's pretty much all it says. So the board should be involved in, yes, we don't need this. Yes, we should sell it. So the board should be doing that, which I hope you all would be doing anyway. Is that it? Yep.
So if you're selling, you have surplus items, I'll just say meters, and
Okay.
another agency wants to purchase them. We talked about the intergovernmental agreement. So should you have a written document that is an intergovernmental agreement, or can you just agree that, okay, this agency wants to buy it for this amount and we're just going to sell it to them?
If you're selling it to them, I would recommend doing it by contract because you want to hold everybody accountable. If you're just donating it, which is an option, I think that your rules could allow you to just do that. Like, we're going to give it to them because we don't need them anymore. But if the deal is, we're going to sell it to them, particularly if it's kind of an ongoing understanding that, every now and then we're going to sell you our extras, I would do that by IGA. Again, there's no competitive process required because it's an IGA. But because it's a contractual transaction, I'd recommend having an actual agreement. It doesn't have to be complicated, but I would do it the IGA. Yeah. Okay, isn't it a fun, you're like, I'm so bored. Yeah, I know. It's a boring
Well, it
topic.
comes up, we do it all the time.
Yeah.
Yeah.
Like, oh my goodness.
Yeah, it does. Yeah, I mean, it is, you all will be involved in it in some way, but it's very hard to teach it, especially in a very basic way, in a way that's even remotely interesting. So thanks for your attention so far.
Any other questions for her on those two subjects? All right. Well, I am one of your facilitators trying to help you out here. And now that this is our 6th one, I know what to look out for, okay? If you ordered a vegan or a dairy-free lunch, it's on that table. If you didn't order that, please don't take it. I've had that problem lately. The lunches that are over there, they've got drinks in them and everything. There's a variety. Choose whatever you'd like. These 3 were specifically ordered. We'd like you to leave those if you didn't order them. There are tables in the little area here, and there are tables outside with chairs, tables and chairs, both places. You're welcome to use those. Please don't move them around. Use the chairs at that table. Don't bring them off someplace else. We're going to come back at 12:30. Now, there is still a slight water issue, and it's getting major. You're going to see me dancing up here. We may have to make a decision on this during lunch, but right now, we're anticipating that during lunch, it will come back on, okay? So if you need to get in your car and go to the local place, just try to be back by 12:30. We'll give some flexibility if that's the case, okay? We apologize. They didn't know this was going to happen. Of course, they couldn't share it with us. We thought maybe it was construction related. It's not. It is facility, but it is the entire complex. It's not just this building. Okay? Anything else?
Okay.
Kaylee, did I do good? All right, go to lunch. Enjoy yourself best you can. It's good creative issues.
Pardon the pun.
That was good. That was good. Worst case scenario, see what happens. I mean, we're gonna have to figure some point of choice.
Or given the option. We'll understand if they need to leave because there's no backup. Stick it out for 4 more hours. Some will have more trouble with that than others. Yeah. You have to put the apparatus where you could just go do it behind the
Toward the vineyard.
Toward the vineyard and just, have a moment.
Yeah.
Just need a quiet moment alone.